Yes.
Also, I beg to mention item number 3 of today's list. Also, the senior advocate, Mr. A.M.
Another day.
Maybe on Friday, Lordship, some emergency is there. Friday, 13th.
Friday.
Item number 12, Your Honor.
Which one?
For adjournment.
Oh,
Number
12, item 12. Admission is there.
As my senior is out of state.
Ah. Adjourn for the day. After 2 weeks?
1 week or 2 weeks.
Okay. Any interim order is there? Interim, no. List after 2 weeks? Yes.
Number 13, Lordship. Matter already been admitted, Lordship,
Hmm.
by the 7-1.
Okay. Already admitted, no?
Yes, Lordship.
So it should come for orders? Order column?
Yes, Lordship.
Order. Admission
Come for
column.
the admission column, Lordship.
Or we can, when the matter comes up, we can pass an order. When the matter, or if you you want it to be adjourned.
Adjourned, Lordship. Already admitted, Lordship. So, 1-3.
1-3, it is wrongly come in the admission column as the matter has already been admitted. List the matter after 2 weeks in the orders column.
Yeah.
Any interim order? No.
No.
Yes.
Yes. Tell me.
I'm praying for adjournment of item number 18, Your Lordship, for today. As engaged counsel have some difficulties, Your Lordship.
Another day. Praise for adjourn. You're for the petitioner? Petitioner. Adjournment for after how long?
1 week.
List matter after 1 week. Date to be fixed by registry. Okay.
But
Lordship, may I seek indulgence in mentioning item number 21, Lordship.
Mhm.
The conducting counsel is out of station, Your Lordship, and I have taken consent from the other side. The matter may be listed in the first week of April, subject to Your Lordship's convenience.
No issues. Praise for adjournment with the consent of the other side. And praise for listing it in the first week of April if possible. List in the first week of April on a date to be fixed by registry. Okay.
In the first week of April.
April. Date, you want me to fix a date or we'll leave it to the registry? They will fix it. Okay.
Grateful.
Does not get listed, you make a mention. Okay.
may I please, Your Lordship? Lordship, I beg to mention item number 36. Lordship, my senior had outstation bench as she is returning back. So, Lordship, kindly adjourn this matter for today. And kindly, the matter may be taken on 24th March.
It is out.
24th March.
Adjourn for the day. Leading counsel being outstation. The IA mainly, no? IA has come up, not today. List the matter on 24/3.
24th. Lordship, I have also a similar prayer for item number 37.
Okay. Okay.
Both the matter
Same.
may be taken on 24th.
When all both matters.
Similar.
Okay. 24.
Highly obliged.
One be item number 1 and 2.
May it please Your Lordship. The petitioner in this case is arrested in connection with a second FIR in relation to the same incident, Your Lordship. Lordship, the first FIR is on page number 13. 301, Lordship. May I read the FIR?
30.
30, Your Lordship.
Okay.
With due respect, I would like to inform that I am working as a Lat Mandal at Ajara Revenue Circle Office. Today on 27/2/2026, on the instruction of Circle Officer Ajara, while later dated so and so, he along with one Jari Karak, Gao Pradhan and police staff proceeded to Kamargaon and Pansipara to serve eviction notice to 26 persons who have illegally settled at the said villages, which falls under tribal belt. At about 3 p.m. on 27/2/2026, when the whole party reached Kamargaon village and pasted one notice at the house of Muhammad Mujammil Ali, suddenly a huge number of people gathered at the spot and created unruly situation. The unruly mob started altercation with the complainant as well as the Jari Karak, namely Minal Kanti Das, and Gao Pradhan, namely Mukut Sharma. The unruly mob restrained the aforesaid staff of Azra Circle Office, who serving the eviction notices and suddenly attacked them as well as the accompanying police party with lathi and pelted stones. As a result, some police personnel and Gaon Panchayat Gaon Pradhan, namely Mukut Sharma, sustained grievous injuries on their body and person. The mob also damaged the police bus bearing registration number so and so by pelting stones. By this act, the unruly mob prevented government officials from performing their official duty. It is to be mentioned that one Muslim Ali, a self-styled Gaubura, has been settling these people at the area by taking money. So that kindly request to investigate the matter, Your Lordship. This is the first FIR, Your Lordship. In connection with this FIR, the petitioner were granted bail. The order is on page number.
This is the first FIR.
First FIR. In relation to this FIR, the petitioners were granted bail. The order is on page number 27, Your Lordship.
By the learned court below, right?
State Cameroon.
Hmm.
Lordship will kindly come to page number 28. Second last para.
Oh, on the ground of on this
And that
on the ground of statutory notices.
Lordship, it was not, sir.
Okay.
On that ground,
Oh,
it
sure.
was, Lordship, in connection with this same incident, another FIR was lodged. This FIR was lodged by the Lat Mandal. The second FIR was lodged by the sub-inspector, Your Lordship. It is in page number 14, Your Lordship.
1-4.
1-4.
And this bail petition is in connection with the second FIR.
Second FIR, Your Lordship.
Sure.
May I read the FIR, Your Lordship? Page 14.
Mhm.
That I am presently serving as sub-inspector in the Ajra police station. That on 27/2/2026, in compliance with verbal instruction of the circle officer Ajra, I, along with the Jari Karak, the village headman, namely Sri Mukut Sharma, and a police team, proceeded to Kamargaon village under Rani Moja, which falls within the notified tribal belt area, for the purpose of serving eviction notices upon certain families who have been illegally occupying government land within the said tribal belt for long. That upon reaching the illegally occupied residence of one Muhammad Mujamil Ali at Kamargaon Ajra, the eviction notice was duly served in accordance with law. That immediately thereafter, a large number of local villagers unlawfully assembled at the place of occurrence and formed a violent, unruly mob. The said mob, in a premeditated concerted manner, initially entered into a verbal altercation with the village headman and the Jarikarak. When the officials attempted to explain that the land in question falls under the tribal belt and that the illegal occupants had been given an opportunity to vacate the land peacefully, the situation escalated.
Hmm. Okay. But the only difference is that in the earlier one, apart from Muzamil Ali, nobody is named. Right? Others are not named, right? But in this, they have listed the number
Lordship.
witnesses
But
Right.
they were arrested. In the first FIR, they were arrested. These people
and released on bail.
released on bail. And
And,
the second FIR,
Again arrested.
again arrested, Your Lordship. Lordship knows in, it is forwarded on 2/3/2026, or 28/2/26 itself, Your Lordship.
Anthony.
And TT Anthony and their judgment of the coordinate bench also. Lordship.
Anyway, so I think this will have to be, it appears prima facie that this will have to be amalgamated. And in that sense, this will be a 161 statement.
Lordship.
So at this stage, what we can do prima facie is that let them go on interim bail. We'll
Lordship.
call for the case diary.
Lordship.
You can give me that.
Lordship.
TP Anthony, I have actually.
Lordship, there is judgment of a coordinate bench.
I'll give- Probably. Prima facie appears to
Same
me.
incident, same
Yeah,
facts
okay.
and circumstances.
Another counsel for the petitioners and learned additional people. The invoking 483 BNSS, the petitioners herein, the petitioner Seher Ali seeking regular bail in connection with Azara PS case number 23 of 2026 under so and so section. Stop. He was shown arrested in this case on 2/3/2026. Full stop. The learned counsel has taken the court through the FIR dated 28/2/2026. The gist of the allegations is that on 27/2/2026 on verbal instructions of the Circle Officer Azara on revenue team went to Komargaon village for serving eviction notices upon certain families purportedly occupying government land illegally, and they reached the residence of one Muzamil Ali. Subsequently, they were resisted by an unruly mob, leading to altercation and obstruction in carrying out their duties. 13 persons are lodged in the FIR, are named in the FIR. Full stop. The Learned Council submits that on with regard to the same incident, another FIR was lodged on 27/2/2026 by Inspector Thanindra Chandra Nath. I've gone through the said FIR. The gist of the allegations is that on 27/2/26, the revenue team went for eviction at the said place, and they were resisted by an unruly mob, creating a situation, and that they were also attacked with lathi and stones. Full stop. It is submitted that with regard to the FIR dated 27/2/2026, which case was registered? This must be a separate case, right?
Last week.
It was registered as Azara PS case number 22/2026, in which the learned court below was pleased to grant bail, however, on technical grounds due to non-compliance with the notices under 47/48 BNSS. Stop. I've also heard the prosecution. Prima facie, it appears that both the FIRs have arisen out of the same allegations and the same incident. Therefore, we call for both the case diaries. Call for the case diary of so and so and so and so, 22 and what the other one? Stop.
22 and 23.
It is well settled as laid down by the Honorable Supreme Court in TT Anthony versus so and so. You give me only that citation, no? That there cannot be more than one FIR with regard to the same incident. Full stop. And any subsequent information would be in the nature of a police statement.
Yeah.
Full stop. Therefore, in the said situation, I am of the considered view that as the petitioners had been granted bail in the earlier case arising out of almost same allegations. Therefore, while this bail petition is adjudicated upon perusing of the case diaries, they should be allowed to go on interim bail. In such view of the matter, allowed to go on interim bail of rupees 20,000 each, with the surety of the like amount each, to the satisfaction of the concerned learned court, CJM,
Kamrup Metro.
Metro, CJM, so and so, and subject to the conditions that they will cooperate with the investigation, shall not hamper or tamper with evidence, shall not commit any illegal activities or offences. What about this one?
Same.
Same order.
Here also considered.
List the matter after.
Second, same FIR.
Date, you can give a date.
25th of March. Second case.
25th of March.
Deeply obliged.
Supply nine. Huh? Of course. Supply fine. Main call?
Alia rejected by.
Oh yeah, tell me. Umsum Bibi, this one.
None appears, but Alia rejected by Lotfi.
Page 15 earlier order.
Paid currency. None appears on call. Stop. However, learned additional PP points out that that this is a subsequent petition. Upon perusing the file, I find that the earlier bill petition was rejected on 9/12/25 in AB 2692 of 2025. We can take stock of the investigation, latest investor. Call for the updated case diary. This is the matter on
Nagaon, my lord. 19.
19.
Bail hearing BA 2425.
Worship, both the matters are connected in the sense, one is a criminal petition
Yeah,
and one is a bail petition.
bill petition.
Now, Worship, that's a difficulty which I am facing.
Hmm,
Criminal petition, Worship, Union of India is not made a party.
I see.
Why affidavit is not been taken on record by the registry.
Because it is not,
Yes.
not a party. Yes,
State has been made a party.
state has been modified. Yes,
Your Lordship, my senior is on legs in another court.
No.
Can it be
okay,
taken
that's
up
okay, no
separately?
problem. We'll wait for him. Sorry saying that in the second case, the criminal revision, right?
Criminal petition.
Criminal petition, the union has not been made a party, so they have not been able to file their objection because it's not been able to.
But they are not
Ah.
expected because state of Assam is a party.
So let our senior come, then we'll sort it out. I think we may have to be implemented since
That's a small
I
correction.
can direct also.
26.
Timing.
Twenty-six.
Nobody.
Yeah, petitioner number 1 was granted interim bail because of pregnancy of his wife.
Hmm. That's right. None appears on call after some. No need to write.
27.
It's busy somewhere else.
After some time.
28.
They are paying? Yes. Informed. Council? No, none. One case diary was called for. Just come, no? Okay. One scan record and one case diary also, I think.
Yeah.
Right?
Can it be in respect of item number 28 and then the CD in respect of another case, cross case.
Cross case.
Cross case.
Lakhimpur PS 418. right?
So far this petitioner is concerned, my lord. In that case, my lord, already submitted, my lord. That's why scan copy was called for.
This one.
Yes.
This one. So what should we do? Should we wait? He's not there. Otherwise,
Then wait for-
informant is there.
Yes.
Everything is ready, so he has to come.
29.
Next.
30.
My lord, sorry, my lord, in item number 29, my lord. Scan copy was called for and the scan copy is up to date till 21/7/25.
No,
So obviously we.
Read the updation.
Yes, my lord.
we'll read the updation. So
Yes.
pass an order then.
Yes, my lord. It's
Let's
the
hold
better,
on.
my lord.
Next, wait.
Because till that time, my lord, one witness was already examined. Trial has proceeded.
Is it a POXO case?
Yes, my lord.
Nawaz is also there in the case.
Yes, Nawaz
He-
is also there.
The learned counsel for the petitioner, none appears for the petitioner on call. Full stop. Mr. Kaushik, learned additional PB, submits that though the scan copy of the case being, what is the case number? It's helping with the case now. Special POXO case number 31
31.
of 2025 has been received from the learned special judge Bongaigaon. However, it is updated only till July
My lord, 21 July 25.
21/7/2025. And the prosecution submits that perhaps up to date this record may be called for. Scan record is not updated, still.
17.
As Nawaz appears on behalf of the informant, a learned amicus appears on the informant. We'll get it updated. Okay,
The name will be recorded because it's not there in the cost.
no problem. Yes. Name of the learned amicus may be reflected in the cause list. Full stop. Call for the updated scan record comprising case diary, charge sheet, and other relevant documents. It is at the stage of evidence
Evidence, my lord.
and deportations, etc. Of special PS case number so and so. Bongaigaon PS 185 of 24 from the special court Bongaigaon. Okay, list on suggested date. You can suggest it.
Can it be on, my lord,
Yeah, without name, how will it be difficult to know again sometimes.
can it be on 30th March, my lord?
Okay, 30th March.
I'm sorry, my lord,
No, we'll take it.
my lord. Service has not been completed, my lord.
27.
27.
Yeah, wait, it is still awaited.
Awaited.
Last date or so it was
My
awaited.
lord. What's my fixed other date, my lord?
You can take instruction, would you? Fine. It appears that the service upon respond number 2 is still awaited. Scan record is available. The prosecution shall take instructions regarding the completion of service with regard to respond number 2 informant. List on
Any date, my lord? 27? Oh, bless.
27/3.
Thank you.
Beg apologies, sir. I missed my item 28.
28.
No problem.
That's it. In this case, there are two cases, let's say.
Hmm.
Not Lakhimpur PS case number 417 and not Lakhimpur PS case number
Yes.
418.
Hmm.
In 417, we are.
CDS come. CDS come.
In 417, PCR has been received probably. Also.
Yes, it is received.
And in the cross case, probably CD was fall also.
It is received.
Actual fact has been narrated in annexer.
Just a minute, I'll come to that. This, where you are seeking bail, that is FIR 812.
812.
812. I've gone through it. 812. He was arrested on 10/12.
Both the affairs are of 812.
Both the affairs. Okay. Hmm. Then, where is the other FIR? Page.
Page 25, also annexer 5, the cross affair. Filed from our side.
This is allegation of assault,
This is allegation of assault. my lord.
and that is the allegation of
Also. What has happened?
earlier order. The last order 9-1. Para 1, 2, 3, 4. 4. Or 5 only even is. One person, I don't know, I've not written. Why was the other person given interim? Because
There is some medical grounds we have.
no, I one for Abdul Barak, but the other are not recent. Both have been given actually. The petitioners were granted interim bail on 9/1/2026. The learned counsel submits that pursuant to their release on interim bail, they have not violated any conditions and are also rendering their cooperation to the investigation and praise for making the said interim bail absolute. Case diary has been received. After some.
30.
My lord, petitioner behind by 87 days, my lord. On the last date, my lord, 9/3/2026, my lord, it was asked to
Adopted child.
submit the status report, my lord.
Can you
Whether the
fix
charge sheet
after
is
some
filed or
time
not,
I
my
will
lord.
take instruction whether charge sheet submitted or not.
My lord.
31.
May I please alert? Relative to application, your lordship, the petitioner filed FIR against the filed by the informant on 4th February 2026.
Mhm.
My lord, kindly see, this case is filed on 7th of February 2026.
Mhm.
Next day fixed for 16th of February for call for the report. But till now, the report is not received yet.
Today also.
Yes,
It's
sir.
come.
Only one report has received. My lord, no FIR has been.
Hmm?
No FIR.
No FIR.
No FIR.
And my lord, kindly see the page number 5 in my petition, my lord. Para number 8. When the FIR or complaint was lodged by the para number 8.
In page 5.
Yes, page number 5. The police constantly visited my house. Even 6th of February 2026 at midnight, they are visited my house and threatened to the petitioner that if I am not my family member, that I am not be able to appear before them, they will appear arrest at any point of time. And subsequently, even 6th of February, sorry, 6th of March, the two police officer have visited my house and threatening me if I am not be appear before the IO, then they will be arrested at any point of time. So my lord, my prayer is that if there is some allegation against me, and definitely I'm prayed before the General Court, can he protect me any point of or not to take any course of action against me. Even my lord, I am mentioning the two phone numbers, para number 10 of page number 5.
There's nothing actually. They
Yes.
cannot arrest you in regard to this because you have this. So you keep an order of this. I'll observe. So if suppose they register, as you know, obviously, after if they register a case, you can come again promptly. But now it is not maintainable. I can learn counsel first 2 paragraphs. The learned counsel submits that as the police personnel of the concerned police station were visiting his house, threatening to arrest. Therefore, he came before this court. Report was called for from the concerned police station, pursuant to which report dated 25/2/26 was received and placed before this court by the Mr. Kaushik, learned additional people. In para 2, it is stated that on 4/2/26, a complaint was received against the petitioner from one Koruna Burra
Yes.
regarding abuse and assault near BK Tower, Ganeshguri.
Yes, sir.
And that subsequently the petitioner went to the informant's shop/hotel at Kailipara and started quarreling and using filthy language and fought with the informant. Full stop. It is stated in para 3 that a general diary entry was made and preliminary inquiry was initiated as per law. However, subsequently, no FIR has been registered nor any police case instituted till date. in view of the aforesaid position, at this stage, the apprehension of arrest would be baseless, and therefore the instant pre-arrest bail application would not be maintainable, of course. Needless to say that if in the future any police case is registered against the petitioner under any non-bailable provision, he would be at liberty to invoke the remedies available in law.
Yes, sir.
That will do.
Possible. I leave it.
This report may be kept in the record. Yes, possible.
32,
Item 32, scan copy receipt, that is very voluminous. I could not go through today. I need some accommodation.
Let him see it. What is it about?
Your lordship, it is about
Explosive substance.
explosive substances and
Only explosive.
Only
substance.
explosive.
No. 109 is also.
109 is there.
Yes, madam. 61(2) is also there.
My learned senior friend shall be given time to produce the document, but I may be protected on interim because police is constantly
No.
harassing me.
Only are taking one day, madam.
As if tomorrow, today only or tomorrow?
Tomorrow.
I have a single bench, no, tomorrow. I think I have.
Oh, madam, this is not earlier rejected, perhaps, madam.
Oh,
We-
then there is no
we said
problem.
Any other things, sir.
Then there is no problem. Yes. You go through, just wait one day. Tomorrow.
Fix tomorrow.
Tomorrow.
Deep.
Scan copy has been received, however, landed additional fee. Mr. Koshik seeks some accommodation due to its voluminous nature. Prayer is allowed. List the matter tomorrow. So and so. Date. At now, we have left to us 8 to 24, 25. Eight a whole. Hmm? 30, but yes, 26. 26. Hold on, 26. After that, hold on. Oh, no. Yes. We just put 25 up to guys.
24, 25.
They have not come yet.
The conducting custody is on his legs in another court. It can pass over the time being.
So I think, again, what do you say? What do you suggest tomorrow? Because Mr. Chaudhary is saying that in the criminal petition connected, the union has not been implemented, only state. So they are not being able to file their objection, right? Okay. It's on tomorrow, both 24, 25.
Lordship, in the criminal petition, but perhaps they have filed the.
No, I have given him a copy, but the.
No, registry is not taking because it's not implemented. So in that, if implement, I was just asking, if implement has to be done, you have to file an IA or the court can just order?
Worship, they can file no, amendment of the
I'm-
first item.
The
The state is.
IA, they have to file an IA probably.
It's not required. Worship. They
It can be ordered also.
You implement the Union of India by the Standing Council NCB. In the
No,
criminal petition.
no. Worship can see, it's the state of Assam.
State of Assam, I think is.
It's just in the criminal,
No, criminal petition, no, standing council NCB is written here also.
Yeah.
Criminal petition also it is written.
no, here, Worship,
State of Assam, yes.
state of Assam.
State
They
of
have
Assam.
state of
But
Assam.
on the right side, they have indicated standing council. Anyway, this can be sorted out.
This
No
can be
problem.
sorted.
Small thing. But actually it is union. It's NCB, no?
It's NCB.
It will be union, NCB. You are representing NCB
Yes,
no?
yes.
Tomorrow.
Time being 26.
State of Assam will be registered also.
Get it corrected tomorrow. You're ready?
The city, yes, there is written.
Since 1811, they are in custody.
But
Oh, they granted interim in between.
his wife was pregnant because of that, malad. One, but I think petitioner number 2 also granted, malad. Petitioner.
Yeah, that's what I was thinking. I have not mentioned any separate reason for petitioner number 2. One,
Well, but now, malad, they have already in interim bail, malad. Otherwise, malad, no such development.
can be, investigation has progressed.
Progress, malad. They are dealing with fake gold, that is there. Malad, other co-accused also, malad, in their statement said that they have purchased fake gold from the accused person. But their statement, I don't know.
এইটো ৰাখি এইটো আগৰ ওপৰ পাৰ্টটো দিয়া গৈছে ওপৰৰ পাৰ্টটো দিয়া গৈছে শিৱক দিছো এইটো এটা লাষ্ট পাৰ্টটোৱে দিম এইটো পিছত প্ৰিভিয়াছ বেইল এপ্লিকেশ্যনৰ পৰা দিয়া গৈছে
Lord, they get interim after 52 days, my lord, in the custody. My lord. That may be considered. My lord.
Their statement is there, malad, accused, I have flag mark, yellow flag.
Will
The
cooperate.
learned counsel submits that at the time of their being granted interim bail, they had already spent 52 days in pre-trial detention. The case diary has been received, and learned additional PP has drawn attention of the court to the relevant portions and submits that the investigation so far as revealed the incriminating materials, full stop. Incriminating materials, comma, lending support to the allegations about the involvement of the accused persons in dealing with fake gold. However, the prosecution has not contested the submission of the petitioner side that during the period of interim bail they violated any conditions or committed any illegal activities. Investigation, seen the progress of investigation, I'm of the considered view that may not be necessary to cancel their interim bail. And accordingly, the interim bail is hereby made absolute, subject to the conditions that they shall cooperate with remaining investigation, shall not hamper or tamper with evidence, shall not indulge in any legal activities or offenses. Return the case there, disposed of.
Highly obliged. I'm okay.
Hmm?
30.
Oh, yes, we were waiting.
I have not received the instruction yet. my
No.
lord.
Regarding completion of investigation, right?
Yes, madam. Regarding.
Otherwise, my lord, 87 days, my lord.
Oh.
Allegation is murder, my lord. Actually, what happened, my lord? The deceased boy, who is a child of 3 years, my lord, he is the
So the
adopted
instruction is
son of the
submitted.
present petitioner, my lord.
Small, no, victim is a small child.
Yes, my adopted son of the present petitioners, my lord. It is an accident, my lord. It is a sadful accident, my lord. I admit it, my lord. But the petitioners are no way involved, my lord. No, my lord, it is only the conspiracy of the first wife of the petitioner number 2, my lord. I categorically stated in my petition, my lord, para 8 and 8, para 8 and para 9, my lord. What the expected incident is, my lord. Page 5, para 8 and para 9, my lord. My lord, initially, my lord, the present petitioner number 2 and his first wife adopted this child, my lord, who is actually the biological parents of this petitioner is the distant relative of the first wife of the petitioner number 2, my lord. Due to some dispute between the first wife and the present petitioner number 2, my lord, they were separated, my lord. Petitioner again married. Now, my lord, due to the said enmity, my lord, the wife of the petitioner insisted the biological parents of the deceased, my lord, to take back the child, my lord. In the meantime, my lord, this incident happened, my lord. My lord, this affair has been lost, my lord, by the cousin brother of the deceased, my lord.
Naturally, because they're alleging that second wife
My lord,
did not like the child, so she killed him,
my
killed her. Anyway, you take the instructions. Don't you think CD will be necessary in this case?
Like 87 days, my lord.
Obviously, scan copy will be required
Mm.
if you're lost it.
Okay, okay.
Voice mail.
CD. So after some time, instruction on. What are they? Really no problem.
Addition at 5,
Arthur.
admission at 5,
So that is 6, 7.
six, 7,
Yes, ma'am.
May please your lordship. Lordship, in this matter, status report was called for regarding the seized zimmer of the liquor, your lordship. Excise department, please. Respondent number 2 is the excise department.
You are appearing?
I am not appearing, but PN Goswami is the for exercise.
Yeah, Mr. Goswami,
PM Goswami will be from the exercise department.
Excise Department. What did you say? Jima status report.
The status report.
Status report. Criminal petition we can actually, but revision I don't think we can because we have to examine the order as it is. Yes.
Your lordship.
But anyway, so. Let us wait. You can inform him, Excise Council. He will be ready with the report.
item number 8,
Yes. Stomach tell.
It's a criminal negligence petition, my lord. It is a judgment and order dated my lord 22/5/2019. Masbel my lord, Lord, Additional District Session Gujarat, reversing the judgment order dated 26/2/2018, passed by under judicial mission first class. They are acquitting all the accused from all the charges, holding that my lord prosecution failed to prove the case beyond reasonable doubt, my lord. But last order can see, my lord. Then, my lord, against the judgment order dated 26/2/2018, appeal had to be filed within 90 days from the date of the order. But here, my lord, the respondent number 3 filed an appeal after 6 months without accompanying thereto any petition seeking condemnation of delay. So on that ground alone, my lord, as per section 3 of the Limitation Act, that appeal is liable to be dismissed. That particular ground has also been taken up during the before the appellate court. It is upon on the written instrument filed by me, my lord. But that ground has not been considered. That last order can listen, my lord. The respondent number Learned Counsel appearing for respondent number 2 and 3 also admitted the same. And Learned my lord, the honorable court, after going to the record and record the same, my lord, the submission made by the Learned Counsel appearing for respondent number 2 and 3. Admitted that after the file shown, the on that ground alone, the judgment order other under passengers is liable to set aside in course manner. The condition appeal was filed on 14/8.
They have come. You're
for
for
the state.
you're for the state.
Other side is not.
Although it is all the sections which are inserted, my lord, they are all available offense, my lord.
It was a GR case.
Yeah. The complainant who lost the FIR, my lord, only he was examined as a PW1. He clearly deposed that, my lord. It is a, my lord, dispute between the parties amicably settled. And my lord, the prosecution did not examine other vital witnesses, my lord.
Should we dispose it of today, or should I fix a date for hearing?
It's clearly, look and see. It is apparent on the face of the record. The appeal is filed beyond statutory period.
Yeah, Lordship.
And that has been admitted.
No, but I have to hear him also. Anyway, if you want to hear us, proceed, I can proceed.
TCR, that trial, TCR has not received it. TCR of that, the trial proceeding, that is not received.
Everything is received, my lord. Learned court last occasion, after going to the TCR, recorded the my lord that
Appellate court's order, TCR has received receipt, but the
Appellate court order is received,
That
but
is
for to decide the issue of limitation, the appellate court order may be sufficient, but to decide the entire case, then definitely trial court is also necessary. But if it is on revision against, conviction over appeal, we have to see that record. But this, the point he has contended, for deciding that this may be sufficient.
yes, my lord, because my lord, they cannot, my lord, appellate court cannot proceed.
That is true.
If there is
Limitation,
a petition saying condemnation of delay.
limitation has to be decided.
And section 3 of the limitation clearly says, if it is filed beyond statutory period, same is liable to be dismissed. I have some other ground, but on this ground alone, my lord, the judgment order is, my lord, is bad in law.
that order I haven't touched.
Can you say the judgment order? Can you see page 39, my lord, appeal file by the respondent number 3.
Now we'll go,
Page 39, my lord. And judgment or trial court is 26 to 2018.
wait,
Yeah.
I'll have to note it down.
Last order of लिखा है। Last order of the
ইয়াৰ পৰা চাব ন দেখাই দিব
So let us start with the dates.
Yes, my lord.
The
Judgment order by
SDGM हो जाए,
yes,
GRK 617
26 to
passes the
2018.
judgment of acquittal on 26 to 2018,
Yes,
right?
my lord.
So limitation action. So the appeal against acquittal 90 days, right? So
40 days, page 39. Page appeal filed by the respondent number 3, my lord.
page 39.
39, my lord. Number page 44, page 42. Appeal start from page 39.
Note.
Page 44, date, verification. Page 44, my lord.
Appeal was filed on
40.
no exclusion benefits, nothing was claimed
Nothing.
in between.
We also took the same plea before a learned my appellate court. You will also find that page, my lord, in my written objection.
At page,
Page, my lord, start from page 53, 11, page 54. The ground A, my lord. This appeal is barred by limitation. But learned appellate first appellate court did not, my lord, discuss anything regarding the same in the impugned judgment order, my lord.
okay. Then the appellate judgment.
Appellate judgment, my lord. Yes, page, my lord. Page, Yeah, page 59, start from page 59.
Mhm.
Section 3 of the limitation Act clearly says, my lord, that the every suit appeal preferred and the application made after the prescribed period shall be dismissed.
So it was decided on merits. This aspect was not gone into, according to you. The points, para 3, points of determination has been formulated. But it is mostly about merits. Anyway,
Nothing
should I go to him?
Yes, ma'am.
Let me hear it. Yeah. Then submit.
I have checked the record, Lordship. Yeah, it's Lordship. In the previous written objection, they have raised it plea in ground number A. It is, I have found it, Lordship, that limitation part they have raised that point, but that has not been, after going through the judgment and order, that part has been overlooked, Lordship. That is the Lordship.
But it is also somewhere I read that the parties have settled the matter also in the meantime.
Yes,
No,
ma'am, yeah. Yes, it is at the time of it.
you do not have that extra instruction.
My lord,
are not
page
saying.
32, my lord. The position of PW1. You
Then I
already,
think it can be disposed of.
yes, ma'am.
Nothing can be done. Anyway, it's third, Mr. FKR Ahmed, Lord Counsel for the petitioner. And you sit down. Your good name, please.
Yes,
P.S. Local and at counsel for the respondent or respondents?
Yes, number one.
additional BP.
Oh, yeah, sorry.
Number one.
Was only one. Review, this is 2 and 3 are not.
Not appearing. Last time they appeared, my lord. Can you say last order, my
That
lord?
we have to check.
Last order, can you say they have appeared and admitted that it is filed beyond statutory period. Last order, my lord. Passed by the my lord Justice Mani Chaudhary. Last time they appeared, my lord, and admitted. Appeal was filed beyond statutory period.
But none appears on behalf of the private respondents being respond number 2 and 3. Stop. Though it is reflected in the order dated 21/7/2025 that Mr. J. Loskor Learned Counsel had entered a variance on their behalf. Full stop. The Learned Counsel for the petitioner submits that he's not going into the merits of the matter at this stage and only bases his contentions on the issue of limitation in as much as the appeal which was filed against the acquittal, judgment of acquittal dated 26/2/2018 passed by the Learned Trial Court was beyond the period of limitation of 90 days. But the appellate court, without going into that aspect of the matter, decided the appeal, reversing the order of acquittal of the Learned Trial Court. Full stop. Right?
Yes, ma'am.
Reversal. Full stop. The Learned Counsel submits that the issue of limitation has to be decided, and as the appeal was barred by limitation, and therefore the same could not have been entertained, and the Learned Appellate Court could not have gone into the merits of the appeal without deciding the question of limitation. On the other hand, the Learned Additional PP fairly submits that after going through the record, he did not find in the appellate judgment about any discussion regarding the issue of limitation. Full stop. Before proceeding further, the facts in brief may be noted. An FIR was lodged on 1/4/2014. Whereupon what was the PS case number? With this so and so PS case number was registered under section, and so we'll fill it up. The corresponding GR number was GR number 617 of 2014. First of the investigation resulted in a charge sheet, and the case proceeded to trial. And the learned trial court delivered
Page 33.
hey, what is the page number?
Page 33.
33. The learned trial court rendered a judgment of acquittal by judgment in order dated 26/2/2018, acquitting the accused persons. Full stop. Agreed by the same, the
Respondent number 3, so-called victim.
the respondent number 3 stated to be the alleged victim preferred an appeal before the learned sessions court, which was additional before the sessions court, which was registered as criminal appeal number 11 of 2018, and came up before the learned additional session just for disposal. Full stop. Drawing attention to the relevant document annexed to the petition, the learned counsel for the petitioner submits that the appeal was filed on 14/8/2018. The said date is reflected in the verification, which is part of the appeal memo. It is submitted that before the appellate court, the present petitioner filed a written objection in which he had taken as ground number 1 the issue of appeal being beyond the period of limitation. The scan record as called for has been received. I peruse the relevant portions thereof. The limitation period prescribed for preferring an appeal against acquittal is prescribed in Article the Limitation Act. What is the article number? Forgetting.
No, the limitation of about section 3.
No. Article 114. So was filed in. This was governed by CRPC, right, at that time?
Yes, sir.
CRPC.
Yes, 114 my lord. Yes.
Yes.
Prescribes a 90-day limitation period for a filing
Yes.
appeal against the order of acquittal.
Article 114 in bracket A prescribes limitation period of 90 days from the date of the order appeal from. Stop. Section 3 of the Limitation Act provides as follows, and maybe reproduce herein will. Full stop. Thus, the question of limitation has to be seen at the time of the application or the appeal, irrespective of whether the limitation has been set up as a defense or not. Full stop. For preferring an appeal against acquittal, the prescribed limitation period is 90 days. And if there is any delay in preferring the appeal beyond the period of 90 days, the said delay has to be condoned under Section 5 of the Limitation Act. Only thereafter, the appellate court can proceed to adjudicate the appeal on merits. In the instant case, the impugned judgment of the trial court was rendered on 26/2/2018, and the appeal came to be filed on 14/8/2018, which was clearly beyond the prescribed limitation period of 90 days. Upon perusing the appellate judgment, I find that in para 3, the learned appellate court has framed points for determination. But the issue of limitation does not find mention therein, though it was contended on the opposite side. The body of the appellate judgment also has not discussed the aspect of limitation, though on the face of, though prima facie, the appeal was filed beyond the stipulated period of 90 days. First. Without going into the aspect of limitation and condoling the delay thereof, full stop, the exercise of adjudicating the appeal was an error and a material irregularity which can be interfered with in this revision. Accordingly, in the given facts and circumstances, the impugned judgment dated, what is the appellate judgment?
22/5/2019.
22/5/2019.
Passed in criminal appeal number
That I've written. Passed in
11 of 2018.
11 of 2018, arising out of GR case number 617 of 2014 dash is hereby set aside and quashed. The criminal revision stands allowed. Any original record has come? No.
No, my lord.
Allowed and disposed of.
Yes, all right.
Right much.
May I please, your lordships? My humble apologies for intervening the list.
Yes.
Item number 32, your lordship. Actually, it was fixed
Oh, yeah.
for tomorrow, but I motionally pray to fix it on day after tomorrow, your lordship, because I have a matter of.
You are appearing
Yes, my lord. Can you fix next week then, my lord? Day after tomorrow.
day after tomorrow. You are not available. I have no problem, but you are not available.
Next week, my lord. Anytime next week.
16th, your lordship, Monday.
I don't know what below. Oh, issue to not.
Deep, your lord.
It was just hold on. What was number? 30?
32, item
32. On 16th. 16th.
May it please your lordship? Your lordship, I beg to humbly mention that item number 29, I was on legs in port number 8, your lordship. Your lordship will fix the date on 30th. Kindly our presence may be recorded, your lordship. Item number 29, your lordship.
29. We fixed it on 30.
30th, yes, Your Lordship.
Hmm? Please. Your good name, please? Did 41, 29. Okay.
Much obliged.
Typing 30.
But I have received the instruction. The first is not yet submitted, but they are trying to submit today, man. Okay. And going by this FIR by itself, well, that girl, you know, she was drowned in 1.5 feet bucket.
Hmm.
Okay, you know,
3 years is still a little,
still
not
on a
so
stage,
small.
Not so small.
Because they can walk around 3 years. Baby, yes, certainly.
1.5 feet
But,
bucket.
since, can I record that?
Yes, my lord, because
Almost complete.
as per my instruction, my lord,
No,
already,
as per your
yes,
instruction.
my lord, investigation is almost done, my lord. Only FSL report they are trying to collect it today, my lord. And after that, they will file the first certificate.
Call for the case diary and charge sheet, if any, in the meantime. List the matter on what will be the 91st day?
As per my calculation, today is 86th day.
Okay.
So 91st will be my
From the date of first remand,
yes.
not from date of arrest.
Yes, from
It
the
may be
15th.
same day, but from the calculation is from date of first remand.
Remanded on 15th, fine.
Hmm?
15th, month. 15th December.
Use a date calculator. It's always better. Anyway,
On Monday, my lord.
list the matter.
On 13th, my lord.
Because no, it won't be 9.
No, my-
Because same exercise.
On 16th.
16.
Acknowledgement.
Number 9.
Lordship, in this case, I think 3 weeks time to file our objection, Lordship.
You are for the informant.
Already informed.
Washing, no? Anything from your side?
Short point, the fixer it, because most of the petitioners are
About to superannuate from the company, because what had happened was there was a contract between A and B. I am C. This contract was a supply of some AC, which was to be supplied by me, C. Now there is a contractual dispute between A and B, a civil suit is filed, and thereafter a complaint is filed. And I have been implemented.
You have also been roped in.
I have also been roped in. I have nothing to do in the underlying contract between A and B.
It is under an order of stay? Yes.
Yes, there is a.
Okay,
I
fine.
only fix it. That's my only request.
Your good name, please?
get out.
K. Taluta, Land Council and Mr.
Elders.
Land Council for the respond number 2, right? 2 weeks time.
2 weeks time.
To file an counter affidavit. The prayer is allowed. Please, the scan record is called for has been received. This is the matter after 2 weeks on a date to be fixed by registry.
Stay interim to continue.
The interim order passed earlier shall continue till the next date of listing.
I am good.
Right order dated 22/3/2023. It's been pending for a long time. No? Yeah.
I was discussing for date to be fixed. If a date could be fixed, then it's a short point. It will not take much time. Any date, in April, any date.
27 March.
27,
Friday. But it is a Friday, but
Then may I request, my lords, for a Tuesday, 31st of March?
Lordship.
Or 2nd of April, any of the.
now you work it out between yourself.
31st of April.
We'll inform the.
We'll inform the court. I'm good.
Time being item 6-7.
Yes.
Your Lordship, I
Forest
appear
matter.
of Excise Department. My lord, we have not been supplied a copy of the brief.
You are for the state excise department.
Excise Department.
So, for liquor, this was seized. I am at. So give him a copy then. Okay.
Sure, Lordship, yes.
Mr. Bothakur, I Bothakur Learned Counsel appearing for the excise department, state excise department, Assam, submits that a copy of the petition has may be furnished to him. The needful may be done by the petitioner side. And which date? Suggested date.
I wrote maybe
List.
on 6th of April.
Next week?
And
List next week on a date to be fixed by registry. They did it like that.
after Bihu, my lord, they are agreeable. Petitioner.
After being
No, it's a long time. After Bihu.
or else, if they can bring the status report on that, on 6th of April.
We
then
will
your lordship-
bring require about 10 days, my lord.
Oh,
After
okay.
that.
You have to get the status report, right? Full stop. In the meantime, the updated status report regarding the material objects in question vis-a-vis their interim, vis-a-vis the prayer for interim custody shall be procured by the prosecuting agency. Full stop. List the matter on 6th April. 6/4.
Obliged.
You have been waiting for a long time. Please come. No. Please come. You have waiting for a long time.
That is when wrongly listed, already admitted, my lord.
Item number 10. It's an NIA case, my lord, already admitted. It has already been admitted.
Oh.
So your lordship has fixed a date for hearing, my lord.
Hearing.
Because it's a concurrent finding of guilt, my lord. So they've been convicted and appeal has been dismissed. Now revision has come, my lord.
We can fix it on a hearing day also because
Hearing date, my lord.
it's a 23 matter.
My lord.
Huh? Concurrent findings of guilt, Mr. B.M. Chaudhary and S. Nawaz, learned counsel appearing for respond number 2/complainant. Stuff. It is submitted that the matter has already been admitted and should not be in the admission call. Full stop. Right order dated 27/7/2023. The revision was admitted. Full stop. The original TCR has been is available. Full stop. This is the matter on mutually convenient date.
21st or 23rd of April, my lord. Hearing dates, my lord.
April. Okay. Fix it. If you are from difficulty. 21st.
21st, my lord. Okay.
Fix on 21/4/2026 for hearing. Huh? 4/4. 21/4 for hearing.
I'm deeply of that.
Item number is back.
Yes. Mr. Ali.
May it please the lordship. But we have filed this petition, my lord, for quashing of the order, my lord. This 32, whereby my lord cognizance has been taken and someone has been issued, my lord. The brief fact of the case, my lord, an FIR was filed, my lord, on 30th of January 2019. Lordship.
You are agreed by the taking of cognizance,
Lordship.
right? In
On the
this
basis of-
complaint case.
Lordship.
Just a minute. No?
Naam dekha hai, sir. Challenge, my lord, two orders, my lord. One, my lord, page 25. Whereby, my lord, the petition has been treated as complaint case.
The Naraji petition.
Lordship.
Page 25. Order dated 22/11/2022. Then the cognizance. Then the cognizance order 23/11.
Cognizance order, my lord, 9/1/2023. Page 32.
9/11. Oh. Cognizance. CR case number 294 of 2022. What a complainant has come, the other side.
My lord, their name has been found.
Because
Apni aise na?
Surojit is. Surojit is. Also.
Oh, no, last date reflects only, it has come after a long time.
Lordship.
17/5 was the last order. So it was returnable to check office note. Because otherwise,
Their name has
complaint
been,
is.
their name has been shown, my lord, in the cause list, my lord.
Yes.
The clear that he appeared.
They have appeared. Okay, we can proceed with your part and we can wait for them a little bit.
Case 15, my lord, is the FIR, my lord.
Yeah.
May I read, my lord.
Go ahead.
With due respect, I beg to state that I am a businesswoman. Accordingly, the below mentioned accused persons purchased 3 trucks of bricks from me in the month of September 2016. The total value of the 3 trucks of brick around 1,07,000. At the time of carried the brick, an amount of rupees 50,000 was paid and balance amount of rupees so-and-so was not
This
paid.
amount is 1 lakh, no?
Lordship.
Wrongly written as typed as I think 10 lakhs. 1 lakh 7.
1,07,000, my lord.
Achha, okay, then cheated me.
Then 50,000 was paid, the remaining was balanced, my lord. And when I called the accused person asking the rate money, he abused me with filthy language and also threatened me with dire consequences. And on the basis of this FIR, my lord, case was registered under section 420, 294 and 506.
Oh.
Then, my lord, police, my lord, investigate the case, and after completion of the investigation, my lord, final report was submitted, holding that there is no materials of the offense, my lord. Final report.
Final report.
Lost. Thereafter, my lord, the learned trial court, my lord, issued notice to the informant, my lord, regarding, my lord, acceptance of the final report. And he filed, my lord, an application. Your lordship will find page 24.
The protest petition.
The informant filed this application, my lord, for reinvestigation of the case. He did not file, my lord, any Narazi petition.
Won't this be a Naraji informed? Nomenclature? Anyway.
No, my lord, Honorable Supreme Court said, my lord, it should fulfill the requirement of the complaint, my lord.
Yeah, that's true.
Here, my lord, there is nothing, my lord, no name of the list of
object against the final report as paid for reinvestigation. Why object? Nothing.
Nothing. There is no materials, my lord. And dear lordship, it is therefore prayed that your honor would be pleased to kind enough to accept this petition and further be pleased to allow reinvestigate the case. Not to, my lord, treat this petition as Narazi or protest petition.
Achha.
On the basis of this application, my lord, next page, my lord, page 25.
Complaint case was registered.
Registered, my lord.
Achha.
And thereafter, my lord.
Are the proceedings an order of stay? They are under order?
No, my lord.
No.
Only notice was issued.
Anyway, so it was registered as a complaint case?
Complaint case.
And cognizance was. Okay. Then the initial deposition.
Initial deposition, my lord, your lordship find page 26. Page 26, my lord.
Yes, I am on 26 only.
Lordship, I have filed this case against so and so. I used to supply bricks. I gave 7 of 8 trucks of bricks to the accused person, and he said that he would pay money in return of the bricks. The accused person issued 2 numbers of check in my favor. The date of one check was expired and another was bounced. Then I called the accused over phone asking money, but the accused person abused me with filthy language and pretended me to dire consequences. The below witnesses would prove the case. And therefore another witness was examined, my lord. Yes.
Some reasoning should be there.
Lordship.
Because
There is
there's a
nothing, no
charge sheet accepting, taking cognizance on the basis of a charge sheet would not require you to write much. Cognizance can be
But
taken.
prima facie, my lord,
But if it
satisfaction.
is, if a final report is overturned, then I think little more has to be
Lordship.
written. Anyway,
Prima facie
come to that.
satisfaction.
See case law also.
On the basis of these two, my lord, witnesses, my lord, cognizance has been taken. Now, lordship kindly see the deposition, my lord.
No, no, what I'm trying to say
Lord.
that if it was a mere complaint case, only a complaint case,
Lordship.
then this much of deposition may be sufficient to take cognizance. Maybe.
Lordship.
But in this case, there was a final report. The police gave its reasoning why final report was
Lordship.
submitted. After that, cognizance was taken.
Lordship.
So there has to be some discussion that why final report is not final report is not acceptable and why this is acceptable. So that's what I'm trying to say. Anyway.
And prima facie, my lord, your lordship, it is the deposition, my lord. Not a single ingredients of 420 or 294 is here, my lord. Purely, my lord, private dispute, private transaction, my lord. Purely civil in nature, my lord. So, your lordship may kindly admit this petition and further proceeding may kindly restate, my lord.
Okay. At this stage, you are seeking admission.
Lordship, admission and stay, my lord. Then
I thought you were seeking disposal at this stage. Anyway, so what I've understood.
Lordship, appearing for the informant, Lordship. So, seeking some time regarding we'll be filing an objection regarding their Naradi petition.
But then you look up the case law, we'll study together. The thing is that what I was trying to tell you, he was there, that suppose charge sheet is filed.
Yeah.
Usually you don't write much taking of cognizance materials and you take. But and on the other hand, 3 things I'm trying to say. So second thing is that initial deposition, something prima facie, some allegations are made. You can take cognizance and in a complaint case, issue notice. But a final form in a police investigation and then you trying to proceed as a complaint case. I think you have to write a little more to justify why I'm not accepting the FR and why I am, because the allegations in the initial deposition are similar to the allegations in the FIR, right? So I'm not reading the narration of IO at this stage, since you are not disposing. Then he's seeking time also. We can admit it. Should I admit? Then it has to be posted for hearing. On a hearing day. Stop. Mr. R. Ali, assisted by Associate Learned Counsel. And you are maybe Learned Counsel for the small number 2. The Mr. Ali, Learned Counsel submits that the Bongaigaon PS case number 64 of 2019, which was registered, resulted in a final report / closure report after completion of investigation by FR number 549 of 2019, dated 31/12/2019. Subsequently, it is submitted that subsequently the informant submitted informant, upon being noticed, submitted a petition before the learned trial court, stating that he objects to the final report. but not stating any grounds of the objection. The learned trial court, by the order dated 22/11/2022, registered a complaint case being CR number 294 of 2022, and thereafter proceeded to examine the complainant and another witness. Thereafter, the learned trial court, by the order dated 9/1/2023, took cognizance and issued summoning order against the petitioners. The petitioners are stated to be aggrieved by both the orders. Mr. Mehdi, however, today seeks some time to file an objection by way of counter affidavit. The scan LCR has been received in the meantime. The respondent side may file its counter affidavit. In the meantime, the revision is admitted for hearing. Leave the matter on, fix a date of hearing. Oh no, it will be in the orders column. Is the matter in the orders column on something or after 3 weeks? Further, allowing the prayer of the petitioner, it is direct in this regard. It is directed that further proceedings in so and so shall remain state in the next date of list. State what the whole could do. List after 3 weeks. Let it come in order first, then we'll fix a date. List after 3 weeks on a date to be fixed by registry.
Apply. Okay.
Break law operator 2 a.m. 2 p.m. now. 15 to 18. This is a concurrent findings of.
Now, they have some difficulty today.
Lordship, the conducting counsel is from Naga Lordship. He could not appear Lordship today.
Actually, this will also, I think, better to fix it for hearing. What do you say?
Up to your Lordship, if your Lordship admits it for hearing, your Lordship may admit it for hearing, madam, in that case, because they have already under a.
No, voluminous file does not mean that the matter is complicated. That's usually it is, but sometimes not also.
Since the counsel is not there,
But today
so rather my lord may fix it for admission, and then if required, it can be fixed for hearing. Only I may pray for a fixed date, madam.
You are for the complainant.
I'm for the complainant.
Counsel for the revision petitioner. Seek some accommodation. Leading counsel is who's? Learned counsel. Leading counsel is from outstation and could not come today. The prayer is allowed. The respondent number 2/complainant represented by Mr. Sarfraz Nawaz. The trial court records in original have been received. Release the matter after
March, if possible.
30 2025 26 in the admission column.
Regarding the next item, my lord, item 16. My learned colleague is there.
Yes, my lord. Yes.
Both of us has agreed for a disposal date on the first week of April.
On a hearing date.
Hearing.
But it's a 25 matter. Usually on the hearing
It's a
date.
DV Act case, my lord. So when the petitioner side have come for quashment of the DV Act case proceeding. So being a DV Act case, my lord, some urgency is also there from our side.
There.
Because there's a stay order, my lord.
That is true. But as you would agree, perhaps on a hearing day, if there are older hearings, that should get precedence. But on a motion day, if we finish the matters, the best to dispose of. What do you say? We'll keep it at admission only.
On the first week of April.
Mr. Roy Chaudhary, yes, for the petitioners, and counsel, and Sarfraz Nawaz for you're the sole respondent. Sole respondent. Any records? No records, it seems, and it won't be necessary.
Only the petition is there on the basis the petition the court had issued.
Record has to be come because the statements are to be.
Statements won't be there, Madam, DBK.
Oh, DBK, so.
So only the petition will be.
This should
there.
be sufficient.
This will be sufficient.
This submit, learned counsel from both the sides submits that the existing materials should suffice for disposal of the matter. Then list the matter, then you take a date.
8th of April, Madam.
See list on 8/4/2026 in the admission column. List. Interim order dated so and so shall remains shall stands extended to the next date of listing.
I'm deeply obliged. Lordship, in this matter, senior advocate D Das is actually, he is the conducting counsel.
Okay.
So he is unavailable in the station now. He's out of station and will be available only after a few days. So this has been conveyed to me just in the meantime, Lordship.
Yeah.
So already matter is stayed.
Achha. It's caution matter, no?
Yes, ma'am.
Caution. Anybody from the other side? No, only state of Assam. Order is state?
Yes, ma'am.
It's not reflected in the last order. It has to be written again then.
LCR was called for in the, if I'm not mistaken, last time.
Mr. Mehdi, learned counsel for the petitioner, seeks another date for this matter as the leading counsel is stated to be out of station. By order dated 18/7/2025, further proceedings of PRC number 332 of 24 pending in the court of learned CGM Bongaigaon was stayed till returnable date and subsequently extended. Said proceedings shall remain stayed till the next date of listing. I'm writing this because last order there was no mention. Anyway, so Mr. Koshik appears for the state / prosecution. But we'll need the record, no? Scan, call for the scan record, scan TCR comprising the, it is a, what states?
It is basically in the evidence state.
Evidence
Yes,
state.
yes.
So, the scan is comprising case diary, charge sheet and other relevant documents, documents, including depositions even. That's right. List the matter after 3 weeks.
1 week if
After a week.
after.
List the matter after a week on a date to be fixed by
Yes,
registry. Registry. Some dates we should leave to them also.
Yes.
1920.
May I please, the Lordship? Lordship, kindly peruse the last order, Lordship, then last paragraph. Lordship.
Okay. But just forest, who's representing Mr.
Lordship,
Chutia?
every operations, Lordship, they are absence. In the last operations, Lordship, in the 9 Lordship, they also absent. And in
And I think the coordination issue, it seems.
yes, yes,
You know, who's representing prosecution part? Forest has other not writ petitions. The prosecutions in forest department who's been assigned. State council should not. This is there. Should come actually because the name is. I'll inform him. Let him come. 1910.
22.
Is an appeal against conviction lawsuit. The influence judgment and order dated lawsuit 30/10/2025.
IA is not come out today. Yes,
I
lordship. I also.
I is for this thing,
I is for lordship for bail.
bail. So anyway, so this needs to be admitted, I think.
Yes.
So is there, so thing is that,
Also been noticed in both the cases. Both the-
notice, but we can admit it.
Yes.
Isn't it?
exactly.
Because against conviction
But
has to
yes,
be admitted,
it's-
right?
it's still to the appeal, lordship.
Mr.
Yes, sir.
I know. Is that Amit, learned counsel for the appellant. The instant criminal appeal has been filed against judgment an order dated 30/10/2025, whereby the appellant has been convicted under section 10 of the POCSO Act and sentenced to undergo rigorous imprisonment for 5 years and pay a fine of rupees 10,000, ID SI for 4 months. Full stop. The appeal being a statutory first appeal against conviction is hereby admitted for hearing. The appellant shall furnish. You have received copies?
My lord, proceed.
Yeah, the prosecution has received copies. However, steps of notice shall be taken upon the respondent number 2/inform through the office of the public prosecutor and to be executed by the concerned through the concerned police station. Full stop. In the meantime, call for the original TCR of POCSO case number 148 of 2023, within bracket Roha PS case number 104 of 23, from the court of the learned special judge POCSO Nagaon. Okay. That's all. That's all. This is the matter. Paper book will be necessary. Paper book.
Paper book usually single judge, my lord, paper book is not prepared, my lord.
Yeah, so it all depends on actually the quality. Nowadays, depositions are usually typed.
Yes.
Paper book is a very, very convenient thing, I'm telling you, in all cases.
Paper-
Any kind of appeals, you know, I was thinking that we should invest more in these paper book divisions of our courts. It can really help things. Wherever I've handled paper books, is very, very convenient. Civil, criminal, everything.
Paper book prepared.
Should I? Correct. The registry, no, record, after the TCR is received, the registry may prepare paper books in sufficient number of sets. In 4 sets, actually. 4 sets for convenience of adjudication. This is the matter in the orders column. After 4 weeks, on a date to be fixed by the registry. Yes, I will pass an order. IAU, what is the conviction is 5 years, right? So here also you have to issue notice.
Yes.
Interlocutory application filed in the context of judgment and order dated so and so, whereby the applicant in this proceeding, interlocutory proceeding, is seeking suspension of sentence and bail and stuff. Original TCR has been already called for in the appeal. Issue notice in this upon respond number 2. Okay.
Okay.
Steps may be taken. List after 4 weeks. 4 weeks.
He is in jail, lord, she is a paper book.
She. She.
He's in jail.
3
Okay.
weeks.
Okay, lord, sir.
After 3 weeks.
Lord, sir, 4 weeks. Okay, I was meant to because kind of paper book. After paper.
No, that will take time, but if you want, 4 weeks on a date to be fixed by registry.
23.
Well, in this case, the appellant has been convicted under section 4 of POCSO Act, sentencing to undergo rigorous imprisonment of 10 years.
10 years.
Yes, ma'am. With fine of rupees 20,000.
Similar. Heard Mr.
M.H. Talukdar.
M.H. Talukdar, learned counsel to the appellant. The instant criminal appeal has been filed by the convict appellant against judgment and order dated 17/12/25, passed by the learned Special Judge Golpara in Special POCSO case number 62 of 21, whereby the appellant has been convicted under section 376 IPC, read with section 4 POCSO Act, and sentenced to undergo RI for 10 years and imposed with a fine of rupees 20,000, ID SI for 6 months. Full stop. The appeal is admitted for hearing. Call for the original TCR. The petitioner, the appellant shall also take steps of notice upon the respond number 2/informant, registry paper book or DD full stop. This is the matter after 4 weeks.
I is also there.
I is also similar. Yeah, you perhaps want to file an objection. The I is similar. Issue notice upon the respond number 2. The prosecution is at liberty to file an objection, if any. Full stop. Main report has been issued. Steps of notice upon respond number 2. List after 4 weeks on a date to be fixed by the registry. Okay.
Time being item 1920.
You are appearing in this also.
We are seeking some updated status on whether a confiscation proceeding is going on or not, madam.
Investigation.
Confiscation proceeding.
Confiscation. No, confiscation can only be after proving of guilt.
Yes, yes.
The confiscation is provisional, my lord, subject to outcome of the criminal case.
It can be done like that.
No.
Yes,
No, no, I am asking.
yes, my lord. It can.
In forest, under forest laws,
Yes, if the
confiscation can be done before trial.
before
conclusion of trial also.
Yes, ma'am. If he's acquitted, then the confiscation goes away. Ma'am. That is the
Lordship, kindly.
But anyway, I don't know if that is the law.
Lordship, Lordship, I will satisfy that part, Lordship. Lordship, here, my case, Lordship, kindly see Lordship order, Lordship 5/3/2016. No, Lordship, here order is there, no adjournment and will be given in the next date. Lordship, here in this, since after filing of this case, Lordship, several times, Lordship, instruction has been sought. Lordship, this is the instruction part, Lordship. Now, Lordship, my case is that, Lordship. 8 years back, my vehicle has been seized, Lordship.
8 years back.
8 years back. Still,
No, that's what I was thinking. Suppose, of course, whatever is the law will prevail. But the thing is, unless that is challenged.
Lordship, I have submitted one judgment of our High Court, Lordship. It is on record. It is categorically mentions, Lordship, just regulation number 49 and 42, 1 and 42. Sorry, 49, 41 and 52.
Forest regulation.
Yes. Here, Lordship, 51 is deals, Lordship, the confiscation of the property after the guilty, Lordship. But here in my case, Lordship, since 8 years is gone, no final report, no such sheet, no offense report has been laid before this court below, Lordship. So till date, once, Lordship, and one more thing, Lordship, I have annexed the similar cases, Lordship, where the case has been withdrawn. And ultimately, Lordship, the vehicle has been released. So here in my case, Lordship, my case ought to have withdrawn pursuant to the notification of government notification, Lordship, is there.
You are saying that the confiscation proceeding, you're sure, or you have to take instructions?
I'll take instruction. Let it be on Friday, my lord.
Yeah, that's what I was thinking.
Yes.
Friday,
Friday.
you'll take the instruction and I will complete it.
Lordship, I am submitting, Lordship.
Yes, I'll hear you.
Lordship, the confiscating proceeding has been over, Lordship. I have annexed these documents, Lordship. Can we see, Lordship, page number 18? I have annexed, Lordship.
Because, see, the thing is that, I mean, forest regulation, if the confiscation suppose takes place during the trial, obviously person will be aggrieved, because if it is provisionally confiscated and taken away, then the vehicle may deteriorate. And suppose, it is, then even if it is returned back, it may be subject of deterioration. Then it may be, it may also, it may come into conflict with his presumption of innocence, because he cannot, the person presumed to be innocent cannot be visited with any penalties. But for example, we give interim victim compensation, that is from DLSA. We cannot ask the accused to give any compensation at this stage because his guilt is being still decided, right? Anyway, we'll have to refresh. I'll also have to refresh. But which page 18? Let me see what you're trying to say. Show. We'll dispose it off on Friday. Yeah, what is this? This
Lordship,
is the
this is the confiscating order.
Confiscating order.
Lordship, against that order, Lordship, I have initially approached before this honorable court, including the Supreme Court. That
I
part
see.
has rejected, Lordship. Now, Lordship, the peasant petitioners comes before this honorable court pursuant to the notifications, Lordship. There is a notifications, Lordship, kindly come into page.
Just a minute. Then if the Supreme Court has rejected the
Rejected,
Jima petition,
Lordship, rejected. Lordship,
Then-
kindly come into page 23. 23, Lordship. This is the notifications of
withdrawal of cases.
yes, Lordship. So similar same footing cases, Lordship. That case has been already withdrawn. Lordship, kindly come into page 31. This is the Lordship, page 23 is the notifications, and page 31. Lordship, this is the similar situated case, Lordship. This is the search sheet, Lordship. And this case has been withdrawn. Their order is there, Lordship. That is page 34.
No, I mean, actually 321 is a call of the public prosecutor subject to the policy of the government. You cannot step into that, but we can always direct, this court can direct, to consider if it falls within the parameters for similar treatment.
Yes,
right?
yes.
That can be done. But for that, there must be orders also of coordinate bench regarding this because notification. But you take the instruction. Then what else should I see? This is, no, from his side.
Lordship, kindly come into page 35.
35.
This is the particular vehicle has been released by this honorable court, Lordship.
No, but the thing is that the Jima matter has been rejected by Supreme Court.
Lordship, I am saying, Lordship, there is the interim confiscating order, Lordship. That I am not going that part, Lordship. Now, Lordship, I am coming before this honorable court when the Lordship criminal case will be closed, then my vehicle will be definitely returned back, Lordship.
In this matter, you are coming for quashing.
Quashing, Lordship.
Quashing of the entire proceedings.
Criminal proceeding, Lordship.
Criminal proceeding.
Yeah, Lordship, in this regard, Lordship, I also submitted one judgment of the apex court. Long pending of investigations, Lordship, it is a ground for quashing. So here in this 8 years,
no, cannot be applied automatically. There are mechanisms to expedite investigation also.
Lordship,
right?
Lordship,
even the magistrate can deal. But that is one principle.
Yes, Lordship. Now, Lordship, kindly come into another judgment I have annexed, Lordship. Given, Lordship. It is on record, Lordship. It is, Lordship, similar situated position in my present case, Lordship. In that case, Lordship, it is a law is.
I'll see. I'll have to see because I have not read the file deeply, right?
Lordship.
So let him take the instructions, whatever instructions. Read up the position, what is to be done. And on Friday, we'll take it up and try to conclude the hearing.
One more thing, Lordship. Lordship, kindly see how many times they are taking in, Lordship. Is still, Lordship, they are not produced any.
No, they will do it. They will do it.
So that's why, Lordship, last occasion order has been given, Lordship. Lordship, kindly see this order, last order, Lordship, last paragraph.
No,
in the after 5 line, Lordship, after 5 line. Kindly see, Lordship, after 5.
I have seen the High Court is, because see, this has a connection with matter going to the apex court also, so it has to be seen carefully. So to Friday.
My lord, one more thing. I know, my lord.
So as I understand correctly, that he is now seeking this is not a Jima matter anymore. Quashing of the entire proceedings. Jima was rejected by Supreme Court. Now it's a quashing of the entire proceedings.
Initially, Lordship, Supreme Court rejected against the Lordship temporary confiscating proceeding, Lordship. There is Lordship is very much aware. Just I would like to refreshment purpose point out.
I have to update also.
Lordship, in sections regulations 49 deals it is a temporary powers has
which
been,
is
yes, Lordship.
The provisional confiscation.
Yes. Lordship, then Lordship it will becomes a 51. 51
which is the permanent.
Lordship, here in my case, since 8 years guns, no, they have not submitted any charge sheet. No trial has been begun. So that's why, Lordship, once now still it is an investigation stage, and in the meantime, Lordship, this notification has been come. It is a petty offense, Lordship, in withdrawal cases, Lordship, and similar situated case already withdrawn, and that vehicle already released, Lordship.
Okay. So, Hawk, learned counsel for the petitioner, who has drawn my attention to the previous order dated 9/3/2026. Full stop. Mr. I. Bhattakur, learned counsel appearing for the Forest Department, submits that provisional confiscation proceedings under the Assam Forest Regulation 1891. 1891 is going on. So, but he seeks some time to, he seeks 2 days time to update the instructions, take updated instructions to them. The prayer is allowed, place the matter on Friday. That means, as I understand, there are 3 aspects to the matter. He is seeking quashing. He is also seeking release of his vehicle, and the interim confiscation was challenge to that was rejected by that has attained finality. Now he is seeking final, quashing of this proceeding. Okay.
Lordship, if possible, Lordship, one observation will be given. Or in the next day, if they fail to produce, Lordship, in a stack.
No, because see, the thing is that I'll keep it in mind, because I've seen from my experience that sometimes this last date, last chance, this becomes, counterproductive.
Lordship, several
something happens on that day, and so
Lordship, Lordship, several times that order has been given, Lordship. Several times in the earlier occasions, 3 times has been given, Lordship.
Anyway,
Lordship.
the learned counsel for the petitioner submit that several dates have elapsed vis-a-vis the position of the respondents, and seeks expeditious adjudication of this, preferably on the next day. Okay, that should be sufficient.
One more request, my lord. I know that several dates were taken. My seniors were appearing, my lord. Now I'm seeking a copy of the brief.
Or should it be on Monday?
Monday would be
Then you
preferred.
can study.
We will get
You can
some
study
more
on Saturday, weekend, no? Friday or Monday. See. No, Friday I was fixing, but okay, there won't be much to study. Just go to the fine. There was a joke in Morigaon on court. They were, the first last time, second last time, third last time.
Lordship.
No, it's slightly counterproductive from my experience. No, Friday.
Lordship, high level, Lordship.
Friday. The same, no? This matters.
Same, Lordship. Just Lordship.
Same order.
One more thing, Lordship, in this item number 19, 20, Lordship, in this just number is difference. Case number as well as, Lordship, vehicles numbers. So in the last order, Lordship, is that
same. It became same.
Yeah, yes, Lordship.
So now I'm not writing to much actually.
High level,
It was at a it is also submitted that in the connected matter, in this matter, criminal petition 1031 of 2025, the vehicle number was inadvertently typed incorrectly in the common order dated 9/3/2026.
Lordship, case number as well as, Lordship. That is
vehicle number and case number.
Case number.
We'll correct it in this order.
Highly.
Okay.
Order item 33.
Ready for hearing? I think.
She's coming. The visitor Sharma is another. She is coming after some time.
Paper book, they are preparing here also, and this is a single bench. It's always helpful, no? Paper book.
Jail appeal. Amaka theory, visitor Sharma is there. She is in other court.
I think it has to be just fixed for hearing. I think
7 years, 8 months already gone.
Already gone. Out to 10 years. 10 years.
Out of 10 years.
No, we'll hear it. Yeah, urgently we'll hear it. Maybe tomorrow if he is ready.
Let's come.
Timing at 5.
Heard matter. We have to do our part. Lordship, the thing is that we are going to withdraw our wakalatnama from this case.
No,
We are
sir.
responding number 2.
You are for the informant, complainant,
Complainant, yes.
complainant.
At the, some time maybe given, we'll provide, send them the notice of withdrawal of the
Yeah.
wakalatnama
Send
and
it,
then we'll provide the same.
So notice of withdrawal. Okay. This matter was, should I keep it as part out or release it? Huh?
Part of
Yeah. This should not be there for very long. Or 28 wanted. This matter was earlier heard on 28/1/2026 and has been kept as part heard. The today the Learned Counsel for the respond complainant submits that they're proposing to withdraw their wakalatnama in this case and with notice to the party and seek some time for the same. Prayers allowed. And then you can tell him we can appear.
That's one date maybe fixed. Part heard matter.
This is the matter after 3 weeks. After 3 weeks on, you want a specific date? No, leave it to the registry. Let us leave it to the registry.
Convenient date we fixed honorable court, Lordship.
No, we don't know actually, no, because we don't have the list. It comes. We're not aware actually how many matters will come. It's given priority.
Yes, ma'am.
But he has to engage a new counsel. We'll take copy. You suggested.
But they also, Lordship, they have took sufficient time. If they are not interested.
26 March. 26 March.
Mile.
Or a week thereafter.
31.
31 March.
That's mile.
31 March. Yes, I'll be here.
Let's answer.
It's on 31st.
Number 34.
So,
Yes, my lord, in this regard, my lord, in the light of the order 4/11/25, my lord, we have taken a dusty step to the respondent number 1, my lord, this complete, my lord. And this is a appeal against the acquittal in the 130th proceeding, my lord. And that proceeding, my lord, neither revert to the evidence nor reduced any evidence, my lord. And absolutely overlooking this, all this evidence, my lord, learned trial court has acquitted that respondent number 1. So we are before this court, my lord. Then 2017 application, my lord, complaint case, my lord. Sorry. The matter already disposal of this matter, my lord.
Leave has been taken. No? Leave has to be taken in these cases.
Already, my lord, already granted.
Already?
Yes, my lord.
After it is listed.
Yes, my lord. And like last time, my lord, this taxi service.
It's also complete.
You complete, my lord, but not represented. And learned trial court also on findings, my lord. It is admitted there is no evidence on the part of the not rebutted the whatever complaint.
The presumptions.
Yes, presumption, my lord. And only the ground, my lord, after deposit return memo that it is taken that there is no seal of the bank, the bank authority, my lord. This is the only ground they have said. And one of the four issue number 4, my lord, that whether the accused person failed to repay the check amount to the complainant within stipulated right, it is decided that it is held that accused failed to repay the check amount to the complainant within stipulated period. As such, the point for determination number 4 decided in my favor. That means for issue number 4 is decided in my favor, my lord. On contrary, stand on the part of the learned trial court, my lord. And
okay, we'll fix a date.
Yes,
the appeal has been admitted, right? Appeal admitted. Heard Mr. P.K. Dega, assisted by your good name, please. Learned Counsel for the appellant, who was the complainant in NI case number 32 of 2018 before the learned additional CGM Kasar Silchar. And that the said trial ended in acquittal of the respondent number 2 hearing.
Respondent 1, my lord.
Oh, sorry, respondent number 1, 2 is just a full stop. In terms of order dated 4/11/2025, dusty service was resorted to. With regard to the respondent number 1, accused, affidavit you have submitted.
Yes, my lord.
Affidavit.
Yes.
It is dusty, no? Must have submitted.
On 28th
Should I check?
January
Yes.
26 we filed.
Order, office note dated 11/11/2025 received, reflects the dusty service system. So no. They have not reflected about the affidavit here. Let us, should I ask them to bring it on record?
My lord, this is my application, my lord. Oh, yes.
It should be brought on the record, actually. It's not in the record, but that's. You filed it, no?
Yes, my lord.
It has not come into the record. The affidavit in compliance with justice service was has been filed by the appellant on 28/1/2026, a copy of which has been placed before this court. However, the said affidavit appear to be in the case record. The same may be brought into the record by the registry and also reflected in the office note. The original TCR has been received. Full stop. None appears today on behalf of respondent number 1. We can fix a date for hearing. Full stop. In the meantime, this will come, I think, affidavit. Then the process would be regular. Stop. This is the matter for hearing. And we'll leave it to them, registry. After 4 weeks. 4 weeks.
Date may be otherwise.
List after 4 weeks on, you can suggest.
My lord, before normally it is not disposed of, my lord. The motion they will be declared. So may I please suggest, my lord?
After view.
My lord, on 21st of April.
21/4.
Deeply obliged, my lord.
Yeah. After lunch or what? Tell me, what is it?
Lordship, I apologize to interrupt, my lord.
No.
My lord, item number 43 of today's list, my lord, orders matters. Just for completion of service, my lord, it has come. So service upon respondent 2 was already done. Respondent 3 also have checked the service note. That is complete, my lord.
Okay.
Respondent 2, my lord, my learned friend, she has already appeared. She is the purported victim, my lord. Compromise has been reached. I have some very urgency, my lord, with regard to a visa, my lord. But can the matter be fixed for admission on 17th, my lord? That's my most humble prayer.
This month.
17th, my lord. So service is complete. Compromise has been reached, my lord.
That roughly hit out is on. Service upon respondent number 2 and 3 stated to be completed. Learned counsel. Your good name, please, madam.
D20. My lord,
25th.
my lord, the date 25th she is seeking.
M. Kapote.
I'm Kakoti. Learned for respondent number 2.
Respondent number 2.
What about 3? 3 is not yet appeared.
3, my lord, service is done, but they not appeared.
None appears today for respondent number 3. Full stop. The learned Mr. Boydha, learned counsel submits that in the meantime the parties have also arrived at a settlement and submits that there is some urgency in the matter as the petitioner is having to apply for a visa for travel abroad. Full stop. List the matter.
We'll try on 17th. If there's unable, my lord, then we'll take it.
List the matter in admission column. Admission. It has been, must be admitted then. Because it has come for orders, no? Must be
Orders,
admitted.
Yes, my lord.
I have not seen the file.
Hearing also, my lord.
I have to see the file then. You're not sure. Are you
My lord,
sure?
to the best of my remembrance, my lord, after motion, it has come for orders.
Usually it comes for admission, but. Okay, so you're right. I don't do this. 17th is a hearing day.
It's a Tuesday, my lord.
Tuesday. Then we can. It's 25 matter, no? Then it will come lower down the list. List the matter on 17.2 in the admission column.
3, my lord.
Huh?
17.3, my lord.
17.3, sorry. In the admission column.
Item number 14.
Oh. Mhm. Yes, yes, do say.
Yes,
Part heard, no?
Yes, sir, part heard.
Just a minute. Can TCRS come?
Yes, sir. Respondent, Lordship is not it.
He's not there.
absent.
So what should we do? Should we proceed or another day?
I leave it to your Lordship.
Against conviction?
A petition under section 143 was filed for interim
Or interim compensation?
compensation in NI Act case, sir. And against which the order was passed, and against which I have approached this honorable court.
You are the accused.
Accused. Their case is, Lordship, they alleged that in the complaint that we issued a check amounting to rupees 10 lakh to the complainant, Lordship. And it was got bounced, Lordship, and thereafter they filed this case, Lordship. During the pendency of the case, Lordship, they filed a petition under section 43A for interim compensation.
Which was allowed.
Which was allowed, Lordship, for an amount of rupees 1 lakh, Lordship. They paid 20%, but the learned court below has
Allowed
granted
1 lakh.
rupees 1 lakh.
It's reflected in the order.
Yes. But in the impugn order, if your Lordship go through the order, it is a very cryptic order, Lordship. We filed a objection, Lordship, and there is a defense on the part of the petitioner, Lordship.
This is the impugn order, this one?
Yes, impugn order is at page
30.
Page 30. Page 30, annexure 7, Lordship.
Already it is part heard, so we can just do a little bit. Then wait for them one day. Fix another day for them.
On the last occasion, I placed one judgment, related judgment, Lordship, Rakesh Ranjan Srivastava, Lordship. In the said judgment, Lordship, Honorable Supreme Court has laid down some parameters.
That's a leading judgment. What is
Yes,
the name?
yes.
Rakesh?
Yes.
Rajesh
Ranjan Srivastava, Lordship.
That is the leading.
I had already played, it was perhaps in the record line.
Should be. Yeah, I get the citation to someone. Okay, impugn order, let's see. Impugn order. Prima facie materials have to be there. Otherwise, interim compensation cannot be given.
Or to have Lordship consider the defense pleaded by the petitioner accused side also, Lordship. If the defense adduced by the Lordship accused is plausible in nature, Lordship, the learned trial court made discretion to refuse to grant any interim compensation. There is no, in the impugn order, Lordship, the learned trial court has not discussed the objection raised by the accused side, Lordship. We objected there are major contradiction in the complaint itself. The complaint, they filed the complaint for bouncing a check of rupees 10 lakh, Lordship. But in the complaint petition, they stated that there was an agreement and accused took an amount of rupees 15 lakhs from the Lordship complainant for providing labors to the bricks factory of the complainant. But the accused in the objection raised the point that, Lordship, the accused delivered labor of 18 numbers of labor, Lordship, but they received only 45, remaining 35 they return back, Lordship. But accused has paid all the amount to the remaining 35. In there are, if your Lordship go through the objection, Lordship, which filed by the petitioner, your Lordship will that will be clear, Lordship. Is at page 27 and 28.
Objection in the?
Objection to the petition filed by the
Before the trial court.
Yes, Lordship.
Before the trial court.
Objection to the petition under section 43A, Lordship. Filed by the petitioner accused, Lordship. There the accused raised the point, the contradiction made in the complainant, and there is another ground was taken, Lordship, that the complainant, Lordship, took 3 numbers of checks and 2 numbers of stamp forcefully from the accused person, and for which they filed a complaint petition before the trial court, and which is pending now. A complaint case was also registered against the complainant. Those things were not properly evaluated by the learned trial court while passing the interim judgment. The straightforward logic granted interim compensation to the complainant. The learned trial court. The parameters laid down by in the case of Rakesh Ranjan Lochik, which laid down that in paragraph number 27 Lochik, there are some parameters in this which were not followed by while passing the impugned order.
Okay, this much over. We'll wait for another day.
Yes, sir, maybe
Next
taken
week.
up after vacation. After two weeks.
After 2 weeks.
Hmm.
No, no, vacation is long time. We'll stop. The petitioner, the revision petitioner is agreed by the order dated 19/6/2025. Is there any issue of maintainability in this case? Will
No,
it be an
because-
interim interlocutory order?
This order passed in a petition under section 143 is not a it is
Not-
intermediate order.
Perhaps. There's a case law also.
Yes, sir.
You submit.
I have with me.
No, next day, huh?
Yes, yes.
Agreed by the order dated 19/6/2025, passed by the learned trial court below, granting interim compensation to the respondent/complainant in the concerned NIACT proceeding. The matter was earlier heard on 9/12/2025. Full stop. And proceeding as part of today. This is, you conclude, this is the learned counsel for the petitioner addresses further arguments and concludes the same. Yours is conclusion.
Yes, my another prayer is that the order passed by the trial court, so
Yes.
it has not discussed the defense pleaded by the accused.
Okay, no problem.
There is a illegality in the order and parameters laid down by the honorable
That I've
apex
written
court has
down.
not been followed. And in my objection filed in the trial court, the petitioner has stated everything under what circumstances the check was issued.
I'll go through it. Addresses the arguments. Concludes the same with a right to reply. None appears on behalf of the respondent number 1 or 2.
There is
Sole
only
respondent.
one.
Sole respondent / complainant. List the matter after a week. 2 weeks, you said. List the matter after 2 weeks on a date to be fixed by registry.
Highly obvious.
Matter shall remain part of.
Interim order passed.
Interim order is there.
Yes, sir.
Interim order passed earlier shall continue till the next date of listing. Past filed order dated today, range suspended. I think 18/8/2025 will remain state till the next date of.
Highly obvious.
Continue to list.
35,
So this report.
For the respondent.
Your father respondent. Appeal against acquittal.
Yes, sir.
Your party was the accused before the trial. What to do? They have not appeared.
Lordship, with regard to the copy of the petition which we have received, the annexures are not there.
Not there.
They will be there.
None appears for the appellant side today. Mr. Learned Counsel, your good name, please? R. Kaur. Learned Counsel appears for the respondent number 2.
Full respondent.
Sole respondent, who was the accused in the accused in CR case number 1946 superscript C of 2013 under NI Act, in which he was acquitted. It is submitted that copy of the annexers are not available in the copy furnished to the respondent. The appellant side shall do the same. Shall furnish the annexers, a complete set of copies with annexers to the issuer side, to the respondent side. Sorry. Original PCR has been received after 3 weeks to be fixed by registrar.
38.
Appeal against conviction, no objection has been filed in the IA till date.
File objection, man.
This is, we are taking out the IA now. What about the appeal? It has been admitted. You're appointed as amicus, right? You are appearing as amicus. Appeal is ready to be heard, I think. No? Right.
If the registry prepares the paper book.
No, that we can do, no? In the paper book we can.
Yes.
That
In
will
the
be
meantime,
convenient.
let them be ready with the paper book.
Heard Mr. Manso and additional people. Second, MK Brown, sorry. Learned Counsel Abicus representing respond number 2. Full stop. The original TCR has been received. The appeal was admitted on 8/4/2025. The registry may prepare a paper book in 4 sets, whereafter it can be furnished to the learned counsels. This is the matter after 4 weeks. This one, 4 weeks.
May I pray for a
date to
fixed
be-
date? Doctor?
Date.
May I pray for a date?
You can suggest a date. Suggest a date.
Do you have a trial of my house?
April. 10th April. 10th April will be. Orders may not come in that day. Then we have that constraint.
After this month.
After Bihu,
It has to go after Bihu because
20th April,
Lordship,
Monday.
Lordship, the IA has to be in the IA. They will have to file an objection.
Conviction is 10 years.
10 years.
10 years.
1.5 years has already been passed.
All are represented. It will be represented first. The original TCR has already been received in connection with the appeal. Full stop. The learned additional PP submits that the prosecution would like to file an written objection to this IA seeking suspension of sentence and bail. It is submitted that the sentence is RI of 10 years.
10 years.
Nothing from your side, at this stage. Let them file the objection.
Lordship.
This one after? Same date.
Same date. Lordship.
Okay. Well, this is 20.
All right, Lordship. Lordship, may I humbly pray that this objection in the IA may be filed at least first week of the date fixed.
The objection, if any, shall be filed in the meantime, with copy in the meantime, with copy to the learned counsel for the applicant, appel. At least a few days before the next date.
Lordship. All right, Lordship.
39.
Wait, please, your lordship. The appeal against conviction. The section 6 to 18 of the POCSO Act. I think there's an IA for suspension. And otherwise the appeal is ready to be heard. If I may pray, date for hearing may be set for
25 matter, no?
yes, sir.
25 matter actually, if I can fix it for hearing, but it will come chronologically.
Yes, sir.
Chronologically.
Lordship may
10 years imprisonment.
place it for the hearing day, lordship, for the
I can fix that, but it will come chrono. If there are no older matters on that day, then we may get a chance. Otherwise, that's a problem.
otherwise I may pray that the IA for suspension may be placed on a hearing day.
That can be done.
Heard Mr. Atre and the RR Koshik. The appeal was admitted on 19/5/2025. Original TCR has been received. Learned Kahus,
I guess so that the
Name is shown well.
Sagarika Borpujari. Two. Probably, is she aware?
I served a copy, lordship.
Okay, she comes now.
Perhaps she's not been appointed in the IA for suspension. That order is in the appeal. 16/2/2026.
In the IA also, full stop. Learned Counsel Sagarika Borpujari is hereby appointed as amicus to represent the respondent number 2 informed. It is submitted by Mr. Atre that copy of the IA has already been furnished to her. Also, her name may be reflected in the IA as well. You file an objection?
Yes.
The prosecution has already filed an objection. So once he comes, we can hear. Should I pick up this now or keep it pending for something? You are seeking hearing, no?
Yes.
Which date did you suggest a date?
Any date, lordship, convening to the court.
This is the matter. You can let's work out a date.
Then
After BU. After BU.
okay.
21 April.
Yes,
Okay, Tuesday.
obligation.
Oh yes, of course. No, I like it. That part is not necessary. Her name is shown in the IA also.
Yes, sir.
Some miscommunication, it seems. You tell her about the date.
I will get it.
40. Item number 40.
That's not-
41.
Yes.
There is a delay application, lordship, in this matter, but also I want to submit on the point that this person, as per custody certificate, already served the sentence of almost 9 years, 7 months, and the conviction was of 10 years.
That should not be. This should not be. Anyway, this is for delay condonation.
Yes, delay 2417 days.
Then we must hear the appeal then, isn't it? We condone the delay, no problem. But there's
POCSO is there,
okay.
section
So
4.
again, notice. No. Can we dispose of this IA without?
Well, so far my knowledge goes that notification is regarding bail and all this.
It can be.
It can be.
So delay condonation, he has a right to be heard.
Yes.
And Chaudhary Learned Counsel for the applicant who stated
It's
to
legal aid counsel, lordship.
legal aid counsel, sorry, legal aid counsel for the applicant who write this application under Section 5 of the Limitation Act 1963 seeking condonation of delay of 2417 days in preferring an appeal, criminal appeal from jail.
Yes,
from
lordship.
jail, right?
Yes, lordship.
Being against the judgment and order dated 8/8/2018 passed by Special Judge Kamrup M in Sessions Case number 68 of 2016, whereby he was sentenced to undergo RI for 10 years and pay a fine of rupees 20,000, ID RI for 6 months. It is submitted by the learned legal aid counsel that the appellant has already has served out
Page 22,
about 9 years, more than 9 years of the sentence.
Page 27.
9 years of the sentence. 9 years of the sentence. The learned additional PP fairly submits that. Mr. Kaushik, what should I record for your side? No objection. No objection.
Regarding delay.
Not delay. Fairly submits that he does not object to grant of delay and hearing of the appeal first. Though the delay is on the higher side, considering the fact that the applicant is seeking to file a criminal appeal against conviction in which a sentence of 10 years has been imposed, and the fact that the criminal appeal has been preferred from jail, that it would be it would be in the interest of justice to condone the delay. Accordingly, the delay of 2417 days in preferring the criminal appeal is hereby condoned. The IA stands allowed and disposed of. Criminal appeal has been registered already. It has been registered. Filing number is there.
Filing number.
The criminal appeal shall be registered expeditiously and put up for admission hearing.
Yes, Lordship.
I was thinking, Mr. Kaushik, that once it is registered, you can fix a date and hear it. Yes, because this should not be, and this situation should never reach, from my, because I'm telling you something. From the one thing is that suppose it goes into acquittal, suppose you cannot rule out completely unless you have seen the prima facie case and you're sure that it is probably they may not be acquittal. Some other changes may be there. Suppose it is acquittal, it's a loss of face. Actually, it's a total violation of constitution. Secondly, there's another aspect which I have realized late in the later years. Actually, see, when a conviction is sentence is there and the person undergoes a significant part of the sentence, and the appellate court might have a tendency to go for upholding the conviction. The objectivity might be disturbed because everybody is a human being. We have to admit this, because he's already undergone 8 years. So it is, the objectivity might be affected. So that situation should not be there. You should see you should hear the appeal in a situation where that, that cloud doesn't come. That he has already undergone, I mean, that kind of tendency might come, that, a stricter view, it may come sometimes. I'm not saying it should not come.
Ultimately,
But
all are
everybody is human being.
ultimately all are human beings.
All are human, of course, ordinary human beings of blood and flesh.
Yes.
A short date may be fixed, Lordship. In 10 days or this.
Any day.
List the matter on. No, this will be, they will do it. No? I cannot
Okay,
fix
they
a
will-
date because this is
Because-
gone.
yes, yes.
Because they have to register and then put it up.
Bless.
Therefore, I mentioned expeditiously.
Oh, bless.
42,
May I please, Your Lordship? My lord, as per the office note dated 26 February, neither AD card nor unserved notice has returned in respect of respondent number 2. He is the complainant.
POCSO matter?
No, Your Lordship. This is under section 419 and 493 of IPC. Cheating by personation and prohibition.
What's a quashing matter? Sorry.
Quashing matter, my lord.
So you have taken steps, but it has not come back.
Yes, my lord.
So what do you say? Suggest we'll wait.
We'll wait for some time, maybe a month, my lord.
Mr. Khan.
A Khan.
Doctor.
Dr. A Khan.
Dr. A Khan, learned counsel, the petitioner, who drawing attention to the pertinent office note dated 26/2/26. Submits that service report is awaited with regard to respond number 2. Informant. Await service report. This is the matter after 2 weeks, 3 weeks, 3 weeks.
Before Bihu, if possible.
They will let us, we can leave it to registry also.
Well, it gets very difficult, my lord, nowadays.
No, that cannot be. That has to be, because nowadays so much technology, no case can get lost because of. So if it does not get listed, then you make a mention.
My lord.
We can fix a date if you are interested. That is not a problem. I am not doing you any favor by fixing a date.
My lord.
Immediately after Bihu?
Immediately after Bihu, my lord.
22.
22, my lord. My lord. Oblige, my lord.
44,
Please, your lordship, appeal against conviction. Lordship, in this case, notice has not been completed on R2 yet.
That's all.
But I've taken steps on 2 occasions. Perhaps, lordship, my case may be appointed at this stage.
POCSO?
POCSO, lordship. Not POCSO, lordship, 376 AB, red with 511.
No. But it proceeded as a POCSO case.
Yes.
I think it proceeded as a POCSO. There's no conviction under POCSO. I think it is.
But the conviction is there under POCSO.
POCSO.
So sentence was under the.
No, that is for 42 POCSO,
Yes.
higher sentences.
Yes.
That's a very stringent provision. Mr. Trade Land Council. This first in the main order. Served, no? You said it's served.
No, lordship, the last report simply says that
Sent.
sent.
Oh, so we will have to wait then.
The report of the OC. We've taken, otherwise we've taken steps on the last 2.
Yeah, the appeal was admitted on 28/5/2025. Service is awaited with regard to respond number 2 informant. Full stop. You take instructions, Mr. Prosecution shall take instructions regarding the service upon the respondent. Stop. The original TCR has been received in the meantime. Stop. This is the matter in the orders column after so and so. In the IA also the same thing. Mr. appears. TCR has been, original TCR received in the appeal, criminal appeal. Stop. Service report awaited with regard. Take instructions. Okay. The prosecution submits that it might file a written objection in this.
May I pray for a date?
After 4 weeks. You want a date?
22nd April.
Yeah, same date, 22nd April.
Publish.
45,
Sure. Scan.
45,
It was received by brother of respond number 2. That'll do. No? None appears for the petitioner on call. Full stop. Scan record TCR has been received. As also the service report upon respond number 2 as indicated by the office note dated 6/3/26. However, none appears on behalf of the respond number 2. In these cases, we need not appoint amicus, not necessary. Admission column. List the matter after 4 weeks. List the matter in the admission column after 4 weeks on a date to be fixed by the registrar.
46.
Right, please, Your Worship. As per office note, my lord, 5/3/2026, my lord, service report is awaited, my lord. This is IA for suspension of offence. Punishment is for 2 years, my lord. I am on previous bail till 17th of March, my lord.
Previous bail.
I have annexed the audit page, my lord, 12th, my lord. Last page of the IA, my lord.
Yeah.
Till 17th of March, I am on previous bail, my lord.
Today is
Today,
11th.
11.
Lots of times. You think that till then I may allowed to remain previous bail, my lord.
We'll fix a date then before 17, so that if it does not come,
Otherwise, LCR is there, but service report is awaited. And punishment is for 2 years, my lord.
POCSO.
No, my lord, 354, 448, my lord.
The appeal has been admitted on 20th January, 26, full stop. Original TCR has been received, full stop. However, service report upon respond number 2, informant, is awaited, full stop. List on, you can suggest a date for his 16. So it will be this Monday only.
This Monday, but I don't think my report will come.
Report may come also, depends. Otherwise, we will have to extend that. Dispose it of IA can it be disposed of on that day, 16th also?
354 is not mandatory.
The Deepak Nair does not only POCSO, right?
Only POCSO.
In the main appeals, he will be there. Should be there. Because he's already on bail, so we don't have to take a fresh call.
Main appeal also might not participatory right.
That it will not problem. Service report awaited. Full stop. It is submitted by the learned counsel for the applicant that after the applicant's conviction sentence on 6/12/2025, he was allowed to remain on bail till 17/3/2026 to prefer appeal before this court. Await service report with regard to respond number 2 informant list on 16/3.
Much obliged.
47.
Yeah.
Here, as per office note dated 17/2/26, we have already taken steps, Lordship. But I have been told by my brother that they have not got a copy. Here, the matter involved is very small, Lordship. It's a very trivial matter. I will file a survey copy to them today, Lordship. Can it be taken up on Monday, Lordship?
Just let me see. This is a revision.
Revision, Lordship. The issue is very simple, Lordship. Here, what has happened, Lordship? I am the informant, Lordship. My son has expired. So I filed a petition before the trial court, Lordship, to play a CCTV footage. In that CCTV footage, every details showing the involvement of the accused person regarding killing of my son is reflected, Lordship. That petition has been disallowed by the trial court below on the ground that those part of the CCTV footage were not sent to forensic. Forensic, what they have done, what the IO has done, Lordship, the CCTV footage was split up into 3 parts. First part and the last part. Now, this incident is included in the second part. I have given a schedule also, Lordship. You will kindly see. Page number.
Today, let us. Are you hearing?
Yes, Lordship. Will kindly fix it on.
We have not received the copy, Lordship.
Oh, okay. Just a minute. You said Monday.
Monday, Lordship.
Monday or Tuesday. You are representing respond number 2. So, he's in custody.
Yes, he is in custody. Respond number 2 and therefore respond number 3 and 6.
3 to 6.
6 respondents are there.
This, this is a criminal revision.
Lordship,
Any
Lordship.
aspect of interlocutory order aspect will
No,
it be
Lordship,
there?
no, it's
Because,
not there. But, Mudulime's judgment is very clear, Lordship. It will be an intermediate order, Lordship, not an
No, I know,
interlocutory.
that is the consequence is more important.
Yes, Lordship.
Consequence is more important. No, because
Absolutely.
there's, you have an excellent remedy by way of a criminal petition. Of course, that's why sometimes to be on the safe side, read with the people write.
Yes.
You know, but it is registered as a criminal revision because
Revision.
just look up and give me, you assess the court on that point because this is the order, the petition for forensic examination.
No.
Sorry, the
For playing the CCTV footage.
because that one
It
don't
is
you-
already in the court.
the prima facie, don't you think that will be interlocutory?
No, it's not an interlocutory, Lordship.
Because something of a say final nature.
Yes, Lordship. My
Final
petition is
nature,
finally
that is
decided
for,
on.
for example, cognizance. Suppose that's not, that does not finish the case. But it's
it does
a
not
serious,
finish the case,
you know,
Lordship.
if cognizance was not taken, that matter would have ended there.
Yes.
So that cannot be said to be interlocutory. But a
Absolutely, Lordship.
petition,
Here, Lordship,
I don't know.
my right, Lordship, has already been decided, Lordship.
petition, I don't know. But since it's filed as a revision. So anyway, so counsel, you can answer. You want a copy of the petition?
We will serve him today itself, Lordship.
The learned counsel for respond number 3, 4, 5, and 6.
3 to 6.
3 to 6. 1 and 2 are state. Sorry, 2 is 1 is state. Mr. Darakulla, learned at the counsel appearing as amicus for respond number 2. The learned counsel for respond number 3, so 3 to 6 submits that he may be furnished with a set of copies. You have received, sir? You have received copies. The petitioner side shall furnish copies. This is the matter on next, let it be next week, if not Monday.
Lordship, the difficulty, Lordship, this is case is in the stage of argument, Lordship. Once the argument is done, my entire right will be redundant, Lordship.
No
And
stay.
This is a we have not prayed for any stay, Lordship.
Okay, let us.
So the stay will unnecessarily delay the matter. The issue is very trivial, very small issue, Lordship. I will be grateful if your Lordship can fix it on Monday, Lordship. Monday will be 16, Lordship.
Or how about Tuesday?
17.
2
Lordship,
p.m.
Lordship.
2 p.m.
17.
Because hearing day, normal course, even if we fix, we don't know whether it will come on reach or not.
All right, Lordship. 17, 2 p.m. not
Revision 20, it's a very recent one actually.
Yes, Lordship, very recent one.
Let
But
it
we
be on Monday only. That will be
Monday.
better. In the normal course, hearing day, we don't know.
It will
Some
be-
old matters come, then it will be a little bit. And you do please do some, young counsel. So you're just on that interlocutory aspect.
that part I will satisfy your Lordship. But Lordship, I am not entering into
No, I am
those
not questioning.
arena of
Just it's come to my mind
yeah, Lordship.
because that aspect we cannot violate. No?
Yes,
Isn't it?
that's-
Isn't it? We cannot
that's-
violate.
Absolutely, Lordship. That's true. No, 16.
16.
Diploma, Lordship.
48.
Okay, topic here.
The I has been, initially I filed an application for criminal revision against the impugned order dated, my lord, dated, my lord, page 21. That is my application, my lord, and the order was passed in page number 36. My lord, I prayed for a stay of the further proceeding. My contention was that I take your lordship the FIR first, my lord.
Okay. We are taking up the IA or this thing?
Your lordship can take the IA, my lord.
IA is for
IA
stay.
is for pass an interim order.
Also.
My lord, if your lordship goes to the original petition, page 17, that is the affair. What happened? I have got a workshop, my lord, at Bongaigaon, and there are several persons are working, and they are taking the collection of the service charge through electric payments directly to their personal account. That way, it appears that more than 50 lakhs have been gone to the accounts of these persons, my lord. These are, I have given their name. Their name are in the page number 18, my lord. There are 9 personnel. Nandakishore, Ilyas Uddin.
Petitioner was the informant.
Yes, informant. Now, case has been charge sheeted, but without seizing the bank accounts, my lord. That's why we have submitted that let there be a verification of bank account and seizure of the bank account. And my lord, first is that IOS fails to collect the key evidence such as bank statement, mobile records, vital witness, testimonials, and which are crucial to prove the charges of the financial misappropriation of theft. The omission of the IO to render this investigation incomplete, and he has failed to investigate the vital evidences. Under 193(9) of the BNSS, the petitioner has right to seek further investigation or reinvestigation when the initial investigation is incomplete.
You are reading this judgment, sir?
My lord, I am reading.
Anantha.
Yes, there is a judgment I have annexed, my lord.
That one?
Yes.
Which para?
Initial by your lordship will again. Page, my lord, page 9 is my IA. Victim has the fundamental rights of fair investigation and fair trial. Therefore, mere filing of the charge sheet and framing of the charges cannot be an impediment in ordering further investigation or reinvestigation or de novo investigation if the facts so warrant. Para 12.3 of the judgment.
Okay.
Para 12.3, my lord, you will get. My lord, applying for the law, 12 I am reading. Applying the law laid down by the court in the aforesaid decision and the principal law laid down in the herein above, it is required to be considered whether a case is made out for further investigation, fresh investigation, or investigation, de novo investigation or not. It required to be noted that in the present case, the allegations of the FIR right from the very beginning were against the accused of number 13, who at the relevant time was in the sitting cabinet minister occupying the high position. Even at the relevant time, when the state police investigated the FIR bearing number such and such in the first charge sheet and second charge sheet, did not name the accused number 13. Even the investigation was also conducted in a perfunctory manner. The real investigation started only after the investigation of the High Court and after passing the various orders in the present proceedings by the High Court. The allegations in the FIR were very serious, including the misuse of the powers by the sitting cabinet minister and abducting, the kidnapping and beating the complainant. The appellant original petitioner filed his criminal petition number Southern Bombay High Court. High Court, an independent investigation agency and the sanction of the 197 for the investigation and the prosecution of public servant. On 23/4/20, the High Court passed the interim order that of the CCTV footage or further evidence collected shall be protected, kept in the safe custody of the Chief Judicial Magistrate. Thane, during the period of 6/4/20 to 29/5/20, the state police recorded the statement of 23 taken as a witness. The real investigation started thereafter. The first charge sheet came to be filed on accused number 1 to 10 and 7/12/20. The accused number 13, then sitting minister against whom the serious allegations were made, even named in the FIR, was not charge sheeted. Even the relevant materials, evidence were collected from the CDR, mobile phone, etc. after the High Court intervened and passed various interim orders. The supplementary charge sheet came to be filed against the accused number 11 to 12 on 28/7/21. The accused number 13 was not even charge sheeted in the supplementary charge sheet. The charge came to be framed against the accused number 1 to 12 on 20. Only thereafter, the supplementary charge sheet came to be filed against the accused number 13. Now, para 13, be that it may, 12(3), even according to the state investigation agency, the further investigation is required. As observed and held by this court, is aforesaid decision, victim has a fundamental right of fair investigation and fair trial. Therefore, mere filing of the charge sheet and framing of the charges cannot be an impediment in ordering the further investigation or de novo investigation if the facts so warrant. This is my case, madam. I pray that, my lord, it is now fixed for evidence of this case, my lord. I pray that at least direction will be given to IO.
That regarding hearing, I am not prepared. My second thing is that, my lord, in Binubhai case, my lord, so from my understanding, although I am not prepared, my lord, Binubhai case said that till once trial starts, my lord, that further investigation is not allowed, my lord. And in this case,
Binubhai, what was the principle? Yeah, it's not a
my lord, kindly
it's a fairly recent
page 37,
of the
Well, not senior French petition matter.
Criminal petition matter,
Mm.
yes. 37, I have
I have
applied
gone through
before.
this once actually.
Yes, madam. The court has already considered.
Take a cognizance, yes.
Evidence
Evidence has not yet started, madam. Cognizance, madam, is not. Cognizance is taken.
Even after taking cognizance. Yes, after cognizance can be,
Can be.
so long as trial is not
After
complete.
charge sheet is also there.
This is the thing. So long as, I mean, if this is the law, then
The stage of trial begins only after charges are framed.
no,
Before
that is
all
clear.
proceedings.
Charges, trial starts when charges are framed.
Yes.
In a criminal
Here
process.
already charges are framed.
But trial, as long as trial is not
Trial is
commenced.
start.
So anyway, so we study it and we'll do it the next day. And the case is at the stage of argument.
No. The evidence has not started.
Also, evidence is not
started. Because we have filed it, that's why we are filing the petition. The matter is pending in the High Court. Kindly wait.
I see.
So you must have disposed the direction of the trial magistrate to hear the matter and to follow the judgment of the apex court. Guidelines of the apex court. This is the judgment of the.
No, I think that will be an order on merits.
Yes.
Yes.
What about the IA? What should we do about the IA?
Because, and I think my lord, private respondent.
You have some urgency regarding stay. You have some urgency regarding stay.
Yes, only a stay. For the timing, your lordship can stay and met me fix for hearing.
Or lordship may fix in next week, my lord.
Okay, I think that will be better
That will
because
be
he's not the accused. He's the
informant.
Informant actually.
The state is the party.
Part of the, like he has initiated the prosecution. So and at his behest, if it is stayed for a little while, till we decide this. That can be done.
Till the next date, madam.
Then the IA will remain pending. You file the IA, no? It will remain pending then till the next date because you have to keep extending them.
Till the further
That will not required because my lord, today it has come for orders. Today it has not come for any hearing, my lord.
If we if we say that the matter is stayed till deciding of this revision, then this will be disposed of.
Yes.
Right. Otherwise, it will remain pending.
Remain pending.
But
Or
even that we can do. We can keep it pending.
Or lordship can fix in next week any date, my lord.
Yes, and if the main matter is disposed of, this will automatically go.
Yes, yes.
The instant application has been filed. The instant application arising out of criminal revision 378 of 25 has been filed seeking stay of the impugn order dated 12/8/2025 passed by learned JMFC Chirang in PRC 176 of 2024. The applicant has filed a revision agreed by the impugn order rejecting his prayer for further investigation. Further investigation.
My lord, here the accused was there because in charge sheet has been filed against one accused.
No, not one accused, all accused.
Yes, then they should have been made party because the further investigation goes. That is against them, my lord.
Further investigation is there.
Because my understanding is praying for further investigation.
They
They may object, my lord, to that.
Yes, otherwise charge sheet has come.
Charge sheet has come. So obviously there are accused. So they should have been made party.
No,
here.
yeah, but
Yes, because otherwise they will be the, my lord, affected party.
So they can come and join, madam.
No, how can they can come and join, my lord?
The moment the order will go, they will come.
No, because my senior friend is basically against the charge sheet. He's not
No, I am
satisfied
not
with-
against charge sheet. Charge
not
sheet
against
is
the charge
there.
sheet, but against,
But
he's
all
not-
the investigation has not been done.
Yes.
Figure has not been made. Bank account has not been made.
No,
CCTV
he's
footage has
seeking-
not been collected.
He's the person who has initiated prosecution.
Yes.
He's not satisfied with the investigation till now.
Yes.
He wants more investigation.
Yes.
That since already charge sheet has been filed against XYZ,
Hmm.
they are also, they will be also affected by
It
the.
will be
further
similar
investigation.
to the other non-POCSO cases. where,
Yes.
If it's not essential.
Yes. Not essential.
But they should have been
But
made party here.
it's better.
In
if they are-
POSCO case, it is essential.
But it's not
No,
essential.
it's not about question of essential on this thing because further investigation, suppose my law state is also agree with further investigation.
Then
They may object. No? Because if further investigation happens, that will go against them also. Because they are the accused person, they are the victim.
Because
Not victim, they are the affected.
right.
Because investigation was not properly done.
Right,
Nothing has been seized.
Right.
That's why I'm here.
But that court will decide.
Otherwise, my application will fail, madam.
The case arose out of. And so PS case number. Oh, it has, what was the PS case number?
PS case no, my lord.
The PRC, the aforesaid PRC number.
176 24.
Pertain to Kajalgaon PS case number 113 of 2024. Under section so and so, page 3. I'll tell you. Good stuff. Then you have to implead. Then you have to implead.
Then it will prolong, my lord. Then trial should be had to have to state, my lord. Yes, further proceeding, I will implead them, my lord.
The interlocutory application seeking stay is kept pending. However, till the next date of listing slash returnable date, further proceedings of so and so PRC number so and so in GMC Siram shall remain state. This will remain pending.
Yes.
They shall remain pending. In the main case, we have to write the scan TCR revision has been preferred, agreed by so and so to assay or what. The scan record has been received. The learned additional PP, Mr. Kaushik, submits that perhaps the accused persons may be required to be impleaded and given a chance of hearing in this petition. Find force in the same side contention. Accordingly, the petitioner may file a I for implement.
Impleading the person.
Implement the necessary persons. Okay. Then we'll hear the matter if possible. This will remain state in the next day.
Developer.
List the matter on after
any date after Bihu, my lord?
After Bihu.
PCR already received one.
No, the trial will scan copy is here.
Yes.
Scan copy to party
Before Bihu, I mean, again, considering that 1 week, maybe only motion week or something like that. After it will be better. 22, 4.
22/4. 23/4 maybe because 22 is the bar council election. We all use 23.
3/4. The hearing day.
33.
It's only for fixing for hearing. Huh?
Fixing on 19. One part we have already inside, but I have to collect the paper book.
Oh, yeah.
We are not paper book also.
Paper book is there. I have to collect it and Lordship may fix it on 19 if otherwise convenient, Lordship.
Copy of the paper book may be supplied to the association.
No, discipline.
Listen.
Public procedure it was served. Kali disseminate.
Okay.
This is a POXO case, no?
376. Service is complete.
No, POXO also. I mean, it was charge is under POXO.
Conviction is 376.
That means not made out. Not made out. POXO not made out because age probably was not proved. Then 376 conviction. Then in this case also this will be required, right? Respond number 2.
Not
376 is not mandatory.
Not mandatory.
Otherwise, the service is complete.
Yes, should I appoint amicus? But it will take some time then. You have to one copy has to be registry will do. So okay. B. Sarma, learned learned amicus representing the convict appellate. Original TCR has been received. Stop. Paper book is also been prepared.
No? Okay.
As none appears on behalf of the respondent number 2, we'll appoint an amicus in this conversation. You can suggest also. You are appearing as amicus, no? Not legal aid counsel. You can suggest someone.
MK Brown, my lord.
Now she has been, I have appointed for several cases, or someone C or someone else. MK Brown, learned counsel. The registry shall furnish her a copy of the necessary copies as well as the paper book. Full stop. We'll fix it on 19A1, no, 19.3 for hearing. No? Matter fix on 19.3 for hearing.
40.
No, but case is there, but nobody is there. Person. Who will do this case? J2. No? Ken copy has not been received. Hello.
Oh, 40. 40 scan copy shown, my lord, in the public. Scan CC has been received.
This does not appear to be. Oh, very thin. None appears today for the petitioner side. The scan TCR has been received. Full stop. Any private respondent? Yeah, it is there.
Another is this regarding service also.
Service report awaited upon respond number 2 as per office note dated 4/2/26. Full stop. This is the matter after 3 weeks. And I date to be fixed by registry. Okay.